May I, Your Lordship? Lordship, in this matter, AAGRS Navam is appearing. He's not present today due to health issue. This matter is listed for tomorrow.
Tomorrow. Okay. Your Lordship, tomorrow my matter is fixed somewhere else in another court. I won't be available. We take it up after vacation.
Yes, Your Lordship, after vacation.
28th of April. I received the affidavit, Your Lordship, yes. I have received the affidavit from the state. Can we fix it on 28th of April? Sure, Your Lordship. What says the present? Keep advocate submits that. So I asked Navam, then Commissioner Advocate General, put on different repositories, especially praise for adjournment. Here is allowed. Affidavit, if any, by the respondents, can be filed least 2 days prior to the next date of listing. List on 28/4/2025.
Yes, Your Lordship.
Item number 2. Will issue a notice here?
Okay.
On challenge made.
So, on connecting matter law, on questioning the same issue, that is petition number 175 of 23. 175 of 23. The same rule has been challenged.
175 of
2023.
2023.
Oh.
Do you remember the pleadings are exchanged in that?
Yeah, already.
Okay. You are Mr. N. Kumar. Your name?
Lord is in item 2.
Yes.
Yes, Lord. I am Naveen Kumar, Lord.
Yes.
Lord, in this case.
We are issuing a notice.
Yes, Lord. My Lord. One small request, Lord. They are trying to auction the subject area, Lord. So.
We'll issue a notice on prayer for interim relief. We are not granting any interim relief right now.
Deeply obliged. Deeply.
For Mr. N. Kumar and constitute the petitioner. Also heard. I don't say that. Next paragraph. By filing this writ petition under Article 56 of the Constitution of India, the petitioner has assailed the provision of section 10 within 10 capital A within bracket 2 within bracket small b of the Mines and Minerals within bracket Development and Regulation bracket close Act of 1957. It is also submitted that there is an apprehension that the mining area allotted to the petitioner may, in the meanwhile, taken over. Next paragraph. Issue notice returnable in 4 weeks. requisite extra. 4 weeks. Mr. Establish and its government accepted notice for
1 to 3.
1 to
1 to 3.
respondent 1, 2, and 3,
And I am for the respondent number 4.
and Mr. M. Katul and then DGI. It's a notice on behalf of respondent number 4. So accordingly, requisite extra copies of the application be served on them within 2 days. You said that issue notice, including notice on the prayer for intent. Returnable ones also. The start of 4 weeks on along with WA 175 AP of 2023, as it is submitted by the learned senior government advocate that in the said that is writ appeal.
No, that's read.
My lord,
petition.
that is also
Petition.
read petition. I am
So,
appearing
read
in that
petition.
also. Read
Okay,
petition
petition.
challenging same provision, my lord.
WPC 175 AP of 2022, where also the same provision has been challenged.
In that case, my lord, pleadings are complete and so far as the state government is concerned.
Yes, we have inquired. List after 4 weeks and along with WPC 175 AP of 2023. Date to be fixed by the registry. Next paragraph. Just before that, you write, it is noticed that in the cost title, comma, the name of the learned counsel for the petitioners is not reflected. So accordingly, the registry shall reflect the name of the learned counsel for the petitioners in the cause list while listing the matter next.
Deeply obliged, my lord. My lord, it's a great pleasure to appear before my lord, my lord. My appearance would come, my lord, Naveen Kumar, Naveen. I'll write in the chat box. Naveen Kumar.
We have recorded your name in the order.
Yes. So it comes N Kumar, so that's
Acha, Naveen Kumar. Okay.
deeply obliged. Deeply.
May I please your lordship? Lordship, in this matter, I've been engaged as a legal aid counsel, lordship. Lordship, in the last occasion, I was directed to file a condonation application. The condonation application is ready, but I have to go down to Teju, lordship. I'm not getting the time to go down to Teju to get his signature of the convicted person, lordship.
You can have it sent to the Secretary District Legal Services Authority and they will communicate. Okay, you are appearing as a legal aid counsel. You
Lordship.
to the Secretary Legal Services Committee here. You can send it across. Don't have to take instance if necessary.
So, lordship, what we can maybe.
Because unless you want instructions, that's another thing to travel to the U. But if you don't need instructions, only for that signature.
Lordship, next week I have a matter, lordship, in Teju. So I am trying, I'll get the signature on that.
Mr. JGP Legal Aid Council has submitted that he could not travel the deal with the appellant is lodged to take his signature in the application for condonation of delay. So accordingly, place for is granted. which time to finish, to do the needful. Next paragraph. We also would like to observe that in the event the learned legal aid counsel does not have requirement to meet the applicant to take instructions, can send a request through the, he is permitted to send a request to the member secretary from our legal services, district legal services authority. This would be which district?
Teju, Lordship, Lohit District, Lohit
Which
District.
district? Have the signature of the petitioner taken in the affidavit. By which on. Sent back. Okay. As per the. Learn. Notice required to be issued? No.
No, Lordship. But Lordship,
This is a condemnation application.
no, Lordship, this is an appeal. The condonation has been delayed, my lord.
But then this has to be admitted.
Yes, my lord. And LCRs are to be called. my lord.
Okay. We admit this appeal. Mr. G.
G. Talo,
Learned
Lordship.
counsel for the appellant. And Mr. G. Talo, learned. I think PP for the state. Next one. I'm sorry, I'm missing your name continuously. Next one. By filing this appeal. The section 415 of BNSS number 2023, or the appellant, who is the convict, in sessions case number 12 of 2023 under section 302 IPC. wherein by judgment and sentence dated 13/11/2023, the petitioner, the appellant was sentenced to undergo life imprisonment and to pay fine of rupees 20,000 with default stipulation. Next part. The appeal is admitted for hearing. Call for the records. So what is it in the section? Is it also there, right? It's in the previous one. Page 11. Call for the record. List after 4 weeks, meeting list of records.
A small prayer, Lordship. Can it be after 3 weeks? There is an IA for sentence suspension of the sentence, Lordship.
302, very difficult. 302, unless we have the records,
Yes,
we will not be able to consider it.
Much obliged.
We give you liberty to make a mention after 4 weeks if it is not tested immediately. Actually, but I think liberty is granted to the counsel for the appellant to mention the matter if the matter is not listed. We give a reasonable time after 4 weeks. I mean, where in the IA we should consider also of it. Which is represented. Yes,
Last occasion, Lordship, question of maintainability was raised.
yes.
So today I've come for hearing of that maintainability, Lordship. Raised by the other
Yes.
side.
We will start.
Yes, sir. The order passed by the learned single judge, my lord, first time was a consent order.
Okay, let us.
It was on the basis of that, my lord, the second order, which is under appeal now, has been passed. If your lordship may kindly page 107. The memo appeal,
7.
yes. Hundred and seven, my lord, starts from 110.
Yes.
110, my lord, I read from the third paragraph. By producing a copy of the order dated such and such issued by the registrar of Neris, Mr. such and such, some is the decision has already been taken in the board meeting, whereby approval has been accorded for implementation of the office orders dated such and such regarding upgradation of faculty members for placement under CAS career issued scheme from the eligible date on individual basis and sanction of financial benefits applicable for them from the due date.
What is CAS?
My lord, this is a career issued progression scheme, my lord.
Career assured progression,
Career advancement scheme.
advanced skill. Okay.
So this was a decision they had taken earlier, but my lord withdrew it, kept it in suspension. Next paragraph. It is submitted by the Lord's Senior Counsel for Neris. The said decision has not yet been implemented in the case of petitioners due to the pendency of the writ proceedings. Then my lord, will kindly have the second paragraph at page 111. It is not in dispute that the decision as reflected in the order dated 12/1/2016 is implemented in the case of writ petitioners. Their grievance expressed in the writ petition will stand redressed. However, the apprehension of the learned senior counsel for the petitioner is that the notification does not lay down any definite time frame for implementation of the scheme. As such, the learned senior counsel prays for appropriate direction from this court fixing a time frame in the matter. In view of the above and taking note of the submission of learned senior counsel appearing for the parties, I am to consider the opinion nothing survives for adjudication in the writ petition. It is, however, made clear that a decision reflected in the order dated 12/1/2016 will be implemented in case of the writ petitioner as early as possible, preferably within a period of 3 months from the date of receipt of a certified copy of this order. So this was the direction. Now, ultimately, this decision taken in order dated 12/1/2016 was not implemented, despite this matter. So accordingly, we filed another writ petition, my lord. There was a contempt, my lord. Ultimately, we had to withdraw that because a subsequent cause of action arose. And this is the page 205, is the order judgment, my lord, that is under challenge. This has been passed taking into consideration this order passed by the Lord single judge at page 110. 27/4/2016.
Yes.
From 207, your lordship will find. Paragraph 3 reflect that the earlier writ petition was filed. It is quoted, my lord, as per 208. Then if your lordship,
Just a moment. Do you have an entire copy of this, the page 107 order?
107 order, yes, my lord, it's here, my lord, from 107.
No, do you have a copy? Because the cost title I'm not finding.
Fine.
The entire cost title is not here.
Post title. My lord, that is filed by them, my lord.
No, that's okay, but do you have a copy?
No, I don't have an extra copy. This is the full copy that is here, but
You come to page 107,
yes,
then 108.
yes,
It starts from.
yes.
I,
Yeah.
wanted
Oh,
to
I
see-
didn't notice it. Man.
I wanted to see the entire.
Yes,
Because whether this party is here.
Yes.
And the parties in page 205 are same.
yes, they are. Actually.
They are.
They
We
are.
take your word for it.
Yes, ma'am.
Okay.
Otherwise, my lord, I can produce it tomorrow.
No, that's okay. I'm just asking you, I'm confirming
That's
it
same
because of the fact that.
Yes, I
have
didn't
to
notice,
take-
but
I have
it's
to
not
take-
my appeal.
I have to take responsibility of whatever I'm passing. That's why I'm asking you. Once you say, since you were the counsel earlier also, we accept your word for it.
My lord, senior will correct me, my lord, if I'm not correct. They are the
That's
same
okay.
person.
No, we have wonderful experience of collusion also.
I think you can find it online, my lord. I can produce it.
No, that's okay. We're not doubting you.
Yes,
It's just my bad nature.
yes, yes. Your lordship website at page 207, your lordship will find that paragraph 3, the earlier order has been quoted.
Yes.
So it is in terms of this orders, my lord, from paragraph 4 onwards. The judgment that is impugned has been, my lord, passed now, directing the Neris to, my lord, comply with the earlier order passed by this honorable court, but the learned single judge was honorable court, and to implement the order dated, my lord, 2012. Now, my lord, the 2016 order was never put to challenge. That is attained finality.
Yes, this is recorded in the order also. In this
Yes.
page 209, it is recorded.
Yes, my lord.
Para 6.
So, my lord, there being no challenge to the earlier order, my lord, how can there be an appeal against the subsequent order that has been passed in terms of the order dated, my lord, 24/7/2016, my lord?
Yes, Mr. Appa.
There was, this was implemented also. After implementation, then arose hue and cry because petitioners are only 5 or 6. But Neris are having more than 26 beneficiaries. They complain saying that if it is implemented as it is, then juniors will be getting more than seniors benefit. Therefore, keep in abeyance order was passed again. Then later on, a committee was set up. And that, Lordship, I'm cutting short. Committee was set up, and this committee, in fact, Neris is governed by entire Northeast. Say Meghalaya, Nagaland, Manipur, so and so. So we have board of management. So Neris director cannot sumoto take its own action, Lordship, and decisions. It's subject to the board decision. Then again, Ministry of Human Development and higher and technical education, they are also members. All the finance is done by the Union of India. Neris is just recommending authority. So there has been objections from Union of India also. Therefore, we try to make the calculation again. So calculation was made and they filed contempt petition also. In contempt petition, we have submitted the correct
But Mr. Apang,
Lordship.
how do you respond to this page 106?
Lordship, that was implemented, Lordship. Beneficiaries, they, Lordship.
No, the question is in the context that after this Board of Management
Lordship.
decision on 12 January 2016, after that came the High Court order, and in this order also at page 106, it is mentioned that financial benefits will be given on finalization of the on the final court judgment.
Lordship.
After that, you say that it has been implemented.
Oh,
Correct.
Lordship, here there were some people they came for before Honorable High Court. Rest they did not. So we implemented for everyone. Then we said that for the petitioners, we'll implement after final order.
Okay.
So on implementation, they withdrew the petition. That is the case.
Okay. But then where is the resolution to withdraw this earlier resolution of 12 January 2016? Where is your Board of Management resolution?
Lordship, Board of Management also, there were two resolutions. After this also, they have said that, okay, we'll implement it. Then it was implemented and they were given benefit for 5 months, Lordship. After 5 months, again, another complaints came. Then it was recommended for larger members and Board of Management decision. Then, Lordship, COVID came in COVID, and it was so difficult to get members also, Lordship, especially this financial matter. Frankly speaking, Lordship, I have not understood what is this. But how calculation of their salary? I have not understood, Lordship. So, but still, Neris is not saying that we are not going to. They are not entitled for case benefit. Neris is saying that yes, it will be given, but for the calculations. That is the case, Lordship. So now the another problem with us is that we are immediate employer of the petitioners. We'll be happy, whatever amount is given to them, we'll be very happy. But we are also depending with the central government because they are the financing authority. So now central government is not coming forward and we are getting the heat from the Honorable Court. Neris is getting the heat, not the Union of India. That's why, Lordship, in this appeal petition, we have met Union of India as respondent, Lordship, so that Union of India respond to it, Lordship. If they say pay, we have no problem, Lordship.
It's the same thing like global meltdown now because of a particular country taking a particular decision.
We are squeezed in between, Lordship.
Everywhere there is a chaos. And incidentally, 3 states were lost. Wisconsin, I can't even remember those names. 3 states in the recent elections have been lost. Same thing, but we can't help it.
In fact, Lordship, contempt petition was filed, and in contempt petition, we have produced we have placed the records before the Honorable Court, and Honorable Court, after seeing that, they have said that this is the compliance.
Ideally,
So
you see,
on that,
I'll tell you something which my father said when I was just became a teenager. It was a very small statement he made, but I also remember it. He said that in life, always live like a tailor. You take measurements twice or thrice, but it is only one time you can cut.
Yes, yeah. So anyway, Lordship, if Honorable Court pass an order, Lordship, specific direction may be given to central government. That is the only prayer. Specific direction, Lordship.
No, but you see, to the Union of India, we can't give a direction.
Lordship, no, they are the respondent number 1, Lordship. They have never filed affidavit.
That is what I'm trying to point
No,
out.
you
Lord.
see, it is then for the management of your board
Lordship,
to come up and say that they are not cooperating.
Lordship, we are saying that. We are saying that.
But because otherwise, you and Mr. Kato, you are both in the writ petition respondents.
Lordship.
Intercept dispute within the respondents, if any. This is not the stage to entertain. It could have been done at the writ petition stage, where we could have given a direction
Yes, yes.
that
That-
the central government would implement it.
Lordship.
But now this direction is against all. It's against the central government also. So now we can't, we cannot elaborate by an appellate court, as an intra-court appeal, we cannot elaborate what the learned civil judge has said. Because that would give a totally different meaning.
But Lordship, in case of financial Lordship matter, if there is discrepancy, then it's question of state exchequer, Lordship. So going for correction, Lordship, if I'm correct, Lordship, it will not be wrong, Lordship. Because we are not saying that they are not entitled. We are saying that they are entitled.
We
What
don't
for the-
say your approach is wrong,
Lordship,
but
that
it
is,
is,
that
we are
is.
saying that it's difficult for the court to accept it.
Now, Lordship, now whether if Lordship, our calculation, second calculation is wrong, Lordship, then it becomes a question of dispute, Lordship. Now, in such financial matter, the dispute is to be educated by the Kate, Lordship.
What
Central
you are-
Administrative
no, no, what you are saying is already covered by page 212.
Yes, Lordship.
Page 212, paragraph 15.
Lordship. Yes, Lordship. Direction has been given to central government.
If they're not implementing it, you have to come and, somebody will have to come and complain.
They are not responding, Lordship. That's why we have made them respondent, Lordship. In this,
They cannot
we have made them respondent, Lordship.
People who have money will not respond. Where did you find it that people who have money will respond so easily?
Because, Lordship, by this order,
This Mr. Kato, right?
Right.
People having money in treasury, they will not respond.
Well, it seems there is in the middle position. They have taken the decision without consultation with the ministry.
You'll have to beg.
And the petitioners is on the other side. So that is the whole problem.
But the direction on you, you are taking a risk.
Malad. That
Yeah.
communication here might have been already made to the Malad, the ministry. Malad.
I don't know.
The equal responsibilities, Malad, in the other way. Malad.
I don't know.
Otherwise, Lordship, for today, may I pray that if a chance be given to the Council for Eastern Central Government to seek instruction as to whether
Rather, what we'll do is that we propose, since we don't find it to be maintainable, we close it and we refer to the refer to your statement as well as paragraph 15.
Lordship.
But we will see in. Yeah.
Om donation lebih Mumbai mulai.
We have taken note of the submissions of Mr. Apang, the issue which he has raised with regard to the central government. And his other submissions also that the nearest in principle is not against it, but they are compelled to do it because of the lack of finance. We take care of it and we'll pass orders. Pass it in chambers just to save time. Which office order? 96. Just a moment. Just flag it. Just a moment. Any other document which we should look into?
No, my lord, otherwise, my lord, since it was a consent order, the first order, my lord, since that was attained, finally, there's, the appeal is not maintainable. And then this is, they cannot raise these other points, my lord, the other issues.
Okay. Mr. Apang, on the facts presented, we will be discussing it, but we take note of your submissions.
Problem.
Item number 6 and 7.
My lord, I'll be using writ appeal, brief of writ appeal 10 and IA 60 for my arguments. They are two analogous matters, Your Lordship. Lordship, before I take you to the brief, I'd like to very briefly present the facts of the case. This is a matter concerning land rights because the diminution of land on a high tension line which is being established in Arunachal. Now, this matter concerns land which is passing through USF forest, I mean, the power line which is
Just tell
passing.
us one thing before you
Yes.
begin.
Yeah.
When this is a case of a drawing up of line
That's
and it has nexus with the Indian Telegraph Act.
Indian Telegraph Act as well as.
Electricity Act is there, but
Yeah,
the Telegraph Act gives the line right of
yes,
way.
yes,
So it's when a electricity power line is drawn up,
yeah,
you only have a right of way which is taken.
that's correct.
Okay.
That's very correct. In fact, we are very much on that point. There is no conflict there. However, there is a misunderstanding in the judgment of land compensation with land acquisition compensation. So they are talking about land acquisition, which we never claimed. We never claimed that there is any land acquisition involved. However, in the procedure that has been specified for identifying affected parties, it is mentioned by the state notification itself that the procedure shall be followed akin to land acquisition. And
Where is the order which was challenged 31/8/23? Where is that?
you mean the impugned order right now? Your Lordship, that is on page 33.
33.
Yeah, 33 to 74.
Is contention. You're reading from where?
Judgment 33 to 70.
You're reading from where?
I am reading from writ appeal 10.
Just give me a second.
You might be on 9, Your Lordship.
Readable 10.
Your Lordship, if you may allow, I'll briefly introduce the aspect, then
Just
take it to the judgment.
We have some queries. Let us clear
Okay,
this query, then we'll hear you.
okay. Well, writ appeal 10, Your Ladyship. Page 56 is the judgment. It starts from page 33.
No, not the judgment.
Which you are talking of in the writ,
The challenge.
Your Lordship, I'll take you to that. Your Lordship. You are talking of the August 23 order. I'll just take it. Your Lordship, come to page 111. Page 111.
May I start from this very page, your lordship, page 100?
Wherever you want.
Yeah, lordship, I'll start from it since your lordship has. So lordship, page 111, this is the impugned notification against which we came in writ. Lordship, para 1 of this notification speaks of a special ex gratia relief package towards right of way for line passing through reserved forest under the comprehensive scheme. I may inform the honorable court that this was preceded by some other notifications whereby it was said that they were. I'll take you to the notification. Now, para 2, your lordship. A, for the tribal population as identified in para 3 of this policy who are not entitled for any benefits. This is what we had objection to, your lordship, because we averred in our pleadings that we are people who are having land rights under the Forest Act, and thereby we should be treated equal to people who have land rights in the USF area. However, it was argued by the state that nobody could have land rights in the forest area, reserved forest area. And thereby this provision was made as a generous gesture from the side of the state government to cover the people who had no rights. Our averment, your lordship, consistently showing different aspects of law, was that under the 2006 Act, our rights have been crystallized. They are not alienable, but they are inheritable, and they are limited to 5 hectares per person. There is a limit based, and they are based on long residency or long usage of that area. We also produced LCs of the petitioners, which were noted as not having been produced in the judgment. I'll take you to that later. We also produced several applications for LCs which are pending. The judgment said that they may be considered and disposed of on merits. That we accept. Thirdly, your lordship, this states, I'm talking of 2A, the relief package payment will be computed at 42% of land value for tower base and 7.5% of land value towards diminution value of land in the width to laying of lines. Lordship, this happens to be 50% of the normal rate. And we'll show you the notification. I'll show you the notification. Last, in B, clause B, your lordship, again, the proposal for bearing calculated cost will be submitted to Ministry of Power. Now, Ministry of Power, your lordship, can give compensation under the Telegraph Act and the Electricity Act, whereby it is clearly specified that full compensation will be given. And mostly that compensation, now this is, that compensation deals with surface damage. This compensation came by a new provision which was brought about by the central government and has been followed by the state government, whereby more compensation has been offered besides surface damage, which is to be given for the diminution of land. Now, my lordship, coming to para C. This is a general clause. Now, para 3, your lordship, clause 3, it is relevant. Earlier, they are saying, in para 2, your lordship, they have held that this compensation or this notification affects people who have no rights. But in para 3, your lordship, they say, board of officers shall be constituted by deputy minister concerned at district akin to board constituted in matters related to land acquisition. The representation first, no, lordship, my humble submission was to the honorable judge that this clearly recognizes that there are land rights which are there under the new Forest Act. Lordship, besides this, there was a notification of on page 114, Your Lordship. Page 114. Notification of 29th August 2019. Your Lordship, by this notification, the state government has adopted the central government norms regarding, this is page 114, Your Lordship.
15. Yes. Yes.
Yes. Your Lordship, first para itself, last 4 lines. Now, this is a provision created by the central government, which has been adopted by the state government under this notification. Your Lordship may notice damages as stipulated in section 67-68, which section shall be in addition to the compensation towards normal crop and damages. So surface
Electricity Act, Telegraph Act. Yes. Yes, please.
Lordship, if you want, I can give you the relevant copy of the electricity. They are having.
Yes, please proceed.
Yes. So, Your Lordship, so there are 2 compensations involved. One is surface damages. The other is what has been notified under this notice. Here, the compensation rate specifies 85% for the base and 15% for the right of way. Your Lordship, these are important. In the previous notification I showed you, they had considered 50%. Now, as Your Lordship was on Electricity Act, section 67, Your Lordship of Electricity Act. I'm sorry, 67 of Electricity Act, which is relevant here, Your Lordship. Since Your Lordship has just got it, I'll just go through that before I proceed further. Section 67, Your Lordship, 3. I read. May I read?
Yes.
A licensee shall in exercise of any of powers conferred by or under this section and the rules made there cause as little damage, detriment and inconvenience as may be, and shall make, I read Your Lordship, this is important, shall make full compensation for any damage, detriment or inconvenience caused by him or by anyone employed by him. Full compensation, there is no provision for half compensation, Your Lordship. The only important Lordship, coming to Your Lordship, may come to page 281. I'm just trying to show what exactly is the factual background. Page 281. Page 281, Your Lordship.
Yes.
This is a notification dated 28th June 23. This is very important, Your Lordship. 28th June 23. This is a notification for invitation of claims and objections. But as your Lordship may see in the fourth para, last line, shall be paid to rightful owners only against the unclassified state forest, USF. This does not include reserved forests. And all notifications after this, particularly one on page 141, Your Lordship. So they have invited claims and objections. Then they have on page 141, dated 5th December 23. Page 141. May I, Your Lordship?
Yes.
Your Lordship, this order, following the earlier order for USF orders, clearly goes for a final joint. They are following the normal procedure for USF forests. So first they invite claims and objections, then they make an order for joint verification. And this exercise was carried out, Your Lordship. And I believe compensations were paid. Now, Your Lordship, on page 133, Your Lordship, and 134, these are actual LPCs of the petitioners. 133 and 134. These are LPCs issued to the petitioners in year 2010 and 2014. Your Lordship, from page 2014 to 2053, I'm sorry, 214 to 253, 214, to 253. These are samples of LPC applications pending with the authority. Now, Your Lordship, the authorities have claimed. May I, Your Lordship?
What is the name of that act? State, Arunachal Pradesh Land Management Act. What is the name of the act? Arunachal Pradesh Land Management Act.
No, my lord, land records and
Land
settlement.
Records Act,
That is in volume 7.
Volume 7.
Land Settlement and Records Act 2000.
आपका book भी है rules का. Yes.
Lordship, since you have just referred to the land, I may point out that the question of land rights is settled in the Scheduled Tribes and Other Traditional Forest Dwellers Recognition Forest Act 2006. Lordship, you may, I'll just hand over copies relevant. Your Lordship,
Yes.
Your Lordship, page, the second page, Your Lordship, C, 2C. It defines forest dwelling scheduled tribes. And in D, it defines forest lands, which includes unclassified and existing or deemed forest land, including reserved lands, Your Lordship. So forest lands includes, then Your Lordship, subsequently, if you come to para 3, Your Lordship, on the third page. On the third page 3. This defines the kind of rights that the tribal has enshrined under this act. And this is where, Your Lordship, the right to be the master of the land comes in the sense of a ownership. It is a non-alienable right. Your Lordship, we have in other states for scheduled caste lands, which are non-alienable, but they belong to them and they are inheritable. And they can do all that any landowner can do with his land. But to protect their rights and to ensure they are not exploited, they are not alienable. And Your Lordship, in next page, para 2, next to page 4, it clearly covers electric and telecommunication lines. E, 2E, sir. Then Your Lordship, further on page 5, second last para. Page 5, second last para. It clearly states what I have just been stating before Your Lordship. A right conferred by substance shall be heritable, but not alienable or transferable, and shall be registered jointly in the name of both person, case of married person, in the name of single head in the case of household held by a single person and the absence of direct heir, etc. Also, there is another condition that save otherwise provided no member of forest dwelling tribe be evicted or removed from forest under this occupation till the recognition verification process is complete. Your Lordship, the important point I am trying to convey while quoting these provisions from this act is that we are not people without any rights. We are people who have land rights in the area, and we have not been given opportunity to submit our claims and objections. That is the pith and substance of my claim, my government's Lordship. Now, Lordship, coming back to the LPC issue, may I take your Lordship to the background of these applications which are pending? And that comes from a judgment in writ petition 20 of 2009. Writ petition 20 of 2009 also, this is starting on page 183, relevant page 205. Writ petition 20 of 2009, starting page 183. Lordship, relevant page 205. 205. Lordship, what had happened in this matter was that several LPCs had been issued in the name of one person. And the court held that this was done by giving by to the due procedure. And the court recommended that these may be cancelled, that procedure was not followed. However, the court said that opportunity may be given, and if due procedure is followed, LPCs may be issued. The important point, Your Lordship, before I take you to this is, again, this clearly shows, and we are talking of exactly the same location where the line is being laid now, Your Lordship. Now, and these are the people whose lands are being violated now by the lines. Now, this did not say, Your Lordship, that they are not there or that their claims are such that they can be rejected forever. But the court held, Your Lordship, I read, there were two sides to it. One is the person who was holding several LPCs. Another were the petitioners who had applied for several, in several names, in their own names, for LPCs which were not being issued. So the court dealt with both the aspects. Para 23, Your Lordship, I read. As regard the petitioners, it has been abundantly made clear that they are illiterate or half-literate indigenous tribal people of the state who have been living in the aforesaid area unconcerned about the rights, privileges, and security. They were equally unconcerned about the necessity of obtaining any document. Your Lordship, this is the reality in the state of Arunachal. Now, towards the end of this para, Your Lordship, the Honorable Court gave a beautiful direction, which is the kind of direction one feels proud of when one thinks of human rights and rights of the people at large. The state must provide, I read, Your Lordship, about 8th, 9th line from the bottom. The state must provide protection to these people under the provisions of 2006 Act, which has recognized the rights of forest dwelling scheduled tribes and other traditional forest dwellers, which has come into force with the publication of the same in the Gazette of Government of India on 2nd January 2007. The government is bound to consider the applications if so submitted by the petitioners for protecting their rights and privileges under the said Act. It is the duty of the government to inform and educate the indigenous people dwelling in the forest their rights granted under the said Act and take necessary action measures so as to enable them to enjoy the said rights. What is happening is just the opposite, Your Lordship. Then, Your Lordship, coming to the next page, page 206. Page 206. I'm reading from middle of the para, Your Lordship, page 24. With the present petitioners and other similarly situated persons, if Such applications are made by them after spot verification, presence of all parties concerned, providing them with due opportunity of hearing, and if on inquiry and when it is found that the respondent or any other person had illegally dispossessed the petition from land over which they have rightful claim, and it is further under the possession. It is also directed state government shall obtain expert opinion about the apprehended destruction to forest. This was regarding construction of some building there, your lordship. Question due to construction of tourist lodge. Your lordship, the sum and substance of your lordship's orders in this matter were: one, people are not educated about their rights. They are not aware of their rights. They should not be exploited. They should be educated and made aware of their rights. Also, clearly said that they must be given opportunity to be heard about their rights. Since order and except that there was an order by the administration cancelling all the LPCs that the name of this person, petitioners had come in this matter. So that one order. So this gives you the background of the pending LPCs, your lordship, pending applications for LPCs. Now, lordship, I will very briefly take you to the legal provision regarding. This is the manual for acquisition. I think your lordship was referring to. Your lordship, this is from the manual for acquisition.
Just a moment.
Yeah, my pleasure, lordship, kindly.
Yes.
Your lordship, this is the manual I have taken of. Now this deals with land acquisition and land compensation also, your lordship. This is what I'm trying to differentiate between land acquisition and land compensation. Land compensation may be for reasons which do not involve complete land acquisition, such as the case in the telegraph line. Your lordship may see the notification manual. Availability of land is for undertaking development projects. 66 kVA line development with the less font of clarity, and whereas, and here it clearly says, and whereas the state government is committed to streamline the land acquisition process so as to provide legitimate and reasonable land compensation to the landowners expeditiously. Lordship, by the very fact that the next duration of land, laying of telegraph cables and towers. the state includes this as part of land compensation. It is not acquisition of land, but there is a element of some rights being taken away. And for that, there is this compulsion. Now, this compulsion, I've already taken you to this page in the reading, Your Lordship. This clearly talks of 85% and 15%. And there is no differential for state forest, unclassified or reserved. It is one right. If you have a right on the land, and if that is being created by the tower and the line, you get the same right. As per this notification. Then Your Lordship, already seen the, I'm pointing these things out just to bring out the errors in the judgment which have come in finally because of some confusion. Maybe my own inability in explaining things. Your Lordship, this is the Electricity Act relevant page on Your Lordship. Now, clause 3, Your Lordship.
That you have already shown us. This 3 you have already shown us.
Lordship, I showed you from Telegraph Act. This is the Electricity Act.
Oh,
That was 67, Your Lordship, if I remember correctly, in Telegraph Act.
67.
67 in Telegraph Act, Your Lordship. This is clause 3 of Electricity Act. The point I am trying to make, Your Lordship, is that this also confirms the provision there in 67 of Telegraph Act.
Oh,
Of,
just on.
This is Electricity Act, Your Lordship, and this is 2003 Act, whereas Telegraph Act is an 1885 Act.
The Telegraph Act does not have 67.
Just read it. Let us give it.
That is in the Electricity Act.
Lordship,
This is Telegraph Act 85 is only 35 sections.
wait a minute, Your Lordship. Actually, I'm feeling very warm. Sorry.
You take rest, just sit down.
Just a minute, let me go to the.
Please sit down. Want to have water?
No, I'm taking water.
Sit down, take rest.
No, okay, let me just take you to the. The only point I am making, Your Lordship, between the Telegraph Act and the Electricity Act is. Your Lordship, Telegraph Act, it was clause 10. Clause 10, Your Lordship.
Section.
And Electricity Act, it is 67, Your Lordship.
Section 10. Act. No, not this is.
Telegraph Act you are referring to.
Telegraph Act, Your Lordship, it is
Section 10.
10. 10B.
Then
10B. I have it here. Lordship, just again. 10B. I have the relevant. My Lordship, just to. Just to point out that the right to fair compensation and transparency in land acquisition, that the 2013 Land Acquisition Act also recognizes the FRA Act of 2006. Your Lordship. I'm just showing that. Clause 3, Your Lordship. Second page, clause 3. Lordship, it says, the scheduled tribes other traditional forests who have lost any of us. Lordship, land acquisition Act also accepts the authority of FRA Act 2006. I am not claiming land acquisition in any way, Your Lordship. All I am saying is we are claiming land compensation for duration. That's number one we are claiming. Second, we are claiming we should be given notice to file our claims and to file claims and objections. Third, the rate given should be the same as rate as per law, the full rate. Fourth, there is a clear break with law if an arbitrary notification is 5% of the rate for people who are not having any rights. With the contradiction is with the clauses I have just quoted from Telegraph Act and Electricity Act, which call for 100% compensation.
Just a minute.
I took you to page 140.
Just tell you why I'm smiling.
Yes, Your Lord.
Can you come to page 222?
222. Yes, Your Lord. This is the LPC, pending LPC.
Yes.
Yes, Your Lord.
Incidentally, this phone number 813-187 down below. 187-3748.
17.
813-187-37.
This phone number. Yes.
This phone number has turned out to be somebody from Munger.
So maybe it has changed because this may be a very old application.
We don't know
I
this.
pointed out to you. Like I pointed out to you, these were taken. I gave you the background of these applications also, Your Lordship. The 2009 order. After that, Your Lordship,
Yes.
what is my request from the court? What is my plea? My plea is not that give me against this LPC or give me against. My plea is the process has not been followed. Please invite objections and invite claims. Then you follow your process. Anybody who does not, who's got a spurious this thing, because these LPCs are taken as samples. The two LPCs which are actually issued are from the petitioners. And if you
This
notice,
this forest area, what is the name of the forest? This forest, where what is the name of this forest where this land is there?
forest land.
You said that this is forest.
This is the reserve forest.
Reserve forest. What is the name of that reserve forest?
I'm not very good with names, your lordship, but I have given from, if you, your lordship notice, page 100.
Just- No, we are not
Lordship,
questioning the
the actual
document,
names are given on the sides. I have given names of all the.
not the names of the persons. The
Not
names,
persons, your lordship,
names
area.
of the name of the forest.
The name
Your
of the
lordship,
reserve
these are-
forest.
I have given names of villages. It's a
No.
reserved forest.
No, we
That's
don't know.
classified.
We
I'm not
don't- no.
aware what the exact names.
But every forest will have a name.
Must be having a lordship.
Like for
maybe
example,
having,
like for
sanctuaries
example,
also in-
Like for example, Gir National,
The
Gir
lordship, I have
Forest.
given the names as I have them of the villages areas along with the map of the poles that we have received. Like Upper Sejosa is there, your lordship, then Niti Darlong is there, then
No,
look,
by name we
okay,
don't understand. Mr. Ratan, are you aware of the name of the forest?
Reserve forest, Pakke Reserve, Tiger Reserve Forest.
Huh?
Pakke, that is Pakke,
PAKKE,
Pakke.
okay. Reserve forest.
Yes,
Yeah.
Tiger Reserve Forest, I believe it is something like.
lordship, there are more than one forest in this. This is what I am trying to say. I am not familiar with the names. If your lordship gives me a few minutes, I can make a phone call and find out. from the client.
Just get it. We'll take a break in a while for
Right, sir. Lordship,
5 minutes. You can.
I'll find out the names. That's my job. Your lordship. I take you to page 155. Page 155, your lordship, it's a very. Page 155, your lordship.
155.
55.
We'll take a short break in.
Hello.
One five five.
Yes, your lordship.
Okay.
This is a FRA certificate, your lordship, when you return.
Come to.
You said so I directed the letter. And it belongs to Mr. Papun Abam, he spoke. So your lordship, I just know myself also and my colleague.
It's okay.
So just maybe some,
Maybe I don't-
writing is- So I just called him, he's in Guwahati today. I don't know him, never met him. And phone पर number भी जो आता है ना, with the Truecaller, I have Truecaller, that also Nabam is.
Okay.
So I thought I'll clarify.
No, this
Then name
correct.
of the forest, your lordship.
Yes.
That also is for the information. It is Papum Reserve Forest. And it is in the division of Kellogg Forest Division.
Just what is the name?
Papum Reserve Forest.
PAPUM.
PAPU. Papum Reserve Forest in Kellogg Forest Division.
In,
Under Kellogg Forest Division.
how do you spell it?
Kellogg, your lordship, I am not very.
Acha, acha. Okay.
So but the forest range I can tell you, Sejosa and Nomura. Sejosa is SEIJOSA
Huh.
and Nomura is NOMUR. So that is the name of the forest.
Okay.
I hope. My lordship, it might be convenient if your lordship allows me to take you to the written submission that I made, which is just 2 pages, 3 pages, which is on
Yes.
page 262. 260. Lordship, after this, if your lordship indulges me, I'll make a suggestion which would
Yes.
help dispose of this matter along with the IAS.
Yes.
Page 62. Lordship, here, I have but I'm saying the regarding the impugned order. The second para talks about the contradiction in para B. Then clause A is regarding, the para A is regarding applicability of land rates, the compensation rates. Where I have quoted the section 10 and 16 of Telegraph Act and section 16 and 68 of Act and referred to the pages. Then B is law to identify affected persons in reserve funds. Lordship, this is what I was really agreeing by. That I was given a go by in terms of being given the opportunity to be identified as a land. Then I have given reference to the, I have already taken a lordship. And then I have gone on to say why the impugned notification is guided in law. Firstly, it talks of 50% compensation to people without any right to it. And I point out this is in violation to both Electricity Act and Telegraph Act, which talk of full compensation to affected people with rights. It cannot be to people who have no rights. Further, as above specified, compensation awarded due to persons with no rights, thus making it illegal for the license or budget to be released. Your Lordship, the central government budget which comes through the Power Ministry is for people who have rights, not for people who have no rights. It's for affected people. And affect means you had a right which got affected. Now, Your Lordship, I have pointed out the notification is self-contributing. Then next page, Your Lordship, 263, I have tried to show that right to property has many colors to it. And Article 300A that you can be deprived of a right to property only by due procedure of law, due process of law. Now, this process which they have invented of people who have no rights and then try to give them 50% compensation is not due process of law. It's an arbitrary notification, administrative notification. Then, Your Lordship, I have gone on to quote the legal, the law that is applicable, which called the field, which is the famous Nazir Ahmad principle, that if a due process is specified, that has to be followed. You can't arbitrarily come up with some new administrative procedure. The same was followed in Banwari Lal case, Your Lordship, then Macmillan McKenzie. Now, very important, Your Lordship, 264. Administrator cannot supersede statutory provisions. Lordship, statutory provision is under FRA Act that we have rights, land possession rights, which may not be exercised under LPCs, which may not be, which may not have been claimed by us because we are a set of relatively backward and illiterate people who, like the court itself described in the 2009 Writ Petition 20 order. But we have rights, Your Lordship, which are being violated or which are being compromised by this process. This is a national project. We also want it, but we must be compensated and identified for the purpose of compensation, for which purpose an invitation for claims and objections has to be notified, which has not been notified in case of reserve funds, which is as per due process of law. So, Your Lordship, I have pointed out administrative order cannot be superseded as written. I have quoted. Now, Lordship, on the last page, 2005, I have quoted from the Writ Petition number 20, 2009, and I have also quoted from another order from this Honorable High Court, where a stay was given in a similar situation and the same was vacated after a due process of taking cognizance of where the poles were being put, what was the damage being caused, etc., was agreed to by the power. Now, Lordship, before taking you to the judgment, the important point I would like to make is the Honorable Judge allowed the proposition placed forward by the state, saying that this is an order in generosity by the state to people who have no right to land, and there is no question of any land acquisition. Now, Lordship, we never raised the issue of land acquisition, though we were accused of having done so by our leading opposing advocates, and I tried to correct them in rebuttal also, that we are not saying land acquisition, we are saying land compensation. Important thing, Your Lordship, is that having allowed and upheld the position of the respondents, that no, there was nothing wrong with the notification, and it was upheld, and this was the exercise in generosity by the state. The law that holds the field today, Your Lordship, on the subject is people who have no rights need to be identified and compensated at the rate of 50%, as per the High Court order. Your Lordship will appreciate, I accept that the law that holds the field today is as per the High Court order, Your Lordship, rejecting our writ petition and upholding the pleadings and the stand taken by the state and power grid. Now, Lordship, under those circumstances, immediately after this order, we have now come to a very interesting situation. Your Lordship, I take you to the IA, number 6022. Your Lordship, page 52. Lord, this notification may actually present a very neat solution to the whole conundrum that I am facing. Here, Your Lordship, page 52, IA 60.
Yes.
Yes. Your Lordship may remember I had shown you a very similar notification where I showed it was for USF only. This is a practically same notification for reserved forest after the judgment. I read, Your Lordship.
Which page?
Second para, Your Lordship, page 52. 5. Now, this is a notification which has come out regarding the reserved forest, identical to the earlier one which I showed you, which had come out, I think, 21 or 23 in the case of USF. So, Your Lordship, I read. Let's read the second paragraph. Whereas the Chief Secretary Government, may I read, Your Lordship, had instructed all the deputy mayors that start survey and assessment work of Tower Foundation area, right of way, and submit estimated diminution cost of land and properties to the requiring agency for payment or diminution to the genuine landowners in the state. Now, Your Lordship, from people having no rights, the notification is asking for exactly what I was asking in the writ petition. I am a genuine landowner, Your Lordship, but the problem here, Your Lordship, is this is not preceded by a notification which is necessary under due process for inviting claims and objections. Like earlier there was, for the USF area there was. I have a humble submission here, Your Lordship, and solution which may be considered by Your Lordship. Lordship, this order actually upholds my position, partly, except that it was not invited, the due process is not correct. I must be allowed process to be heard in terms of my claims and objections. Number one. Number two, Your Lordship, even the honorable judge, single judge, has upheld my stand to the extent that she has said that the pending LPCs must be disposed of as soon as possible. But, Your Lordship, she has held that I have shown no LPCs, which is a error on the face of facts because I had included LPCs. actual LPC, which I showed your lordship. So your lordship, my humble submission and my seeking your indulgence is as follows, your lordship. This notification, your lordship, accepts my position, but it needs to be preceded by a notification for inviting bids and objections. Your lordship may mold the relief in this entire matter, accepting this notification to be postponed till bids and claims are invited. Some time may be given for that, and the order may be the Honorable High Court's single judge order may be considered to have been molded as per this. That is the shortest approach. Otherwise, your lordship, as things stand, this order notification whereby hereby it writes order is against the law as it stands. Now, the law as it stands is people without rights and people who don't have land rights. The state has said in its averments that people in reserved forest have no land rights, which is an error. And we have pointed that out again and again. So, your lordship, my humble submission is in view of. Otherwise, your lordship, if your lordship so thinks, then I'll go to the judgment and go and make my amendments as to the judgment also. But if this path is suitable, then
We don't know, we can't pre-decide. You'll have to present it. If you are challenging that order, you'll have to refer to
yeah,
that.
your lordship, I am also IA for this order. I have also filed a IA. This is an IA for this order. And if in this order, your lordship, there are two things here possibly. One is, I have already shown your lordship what my stand was in the writ appeal, which was rejected. Now, I can go piece by piece in the Honorable High Court's order and point out where I think it may be incorrect. Alternatively, your lordship, a very interesting situation has arisen. The state, by filing this order, has actually accepted my position in the writ appeal, the writ. And by that, the only default now is, see now, if they go ahead with this, I have not been given an opportunity to be heard, which is a basic opportunity and the principles of natural justice, and laid down in the procedures related to land acquisition. I'm not asking on land acquisition. Process that is to be followed as per their own notification is akin to land acquisition. In that sense, only I am using the word land acquisition. So, your lordship, if this notification is the desire, or this order is the desire of the state, it very clearly says genuine landowners in the state. I am one of them, your lordship. Or there are many others whose land ownership rights are with them in whatever format, maybe from British times, maybe some are, in fact, one of the petitioners here has from British times also. And they may be not crystallized at all. They will come to know this is happening, so let me go and file for my land rights. The only thing is, unless objections and claims are invited, this step is bound to be in error. All I am saying, your lordship, is the whole exercise can be limited by passing an order, if your lordship so desire, that invitations and bids may be invited, 20 days time, 15 days time may be given. Normally 30 days time is given, your lordship, as was given in the case of USF. So here maybe 20 days time may be given. And after that, this order may be implemented. That's all, your lordship, that's all we need. And that does complete justice to those who have rights. And I'm not concerned with those who don't have rights.
Yes, Mr. Ratan.
My lord, my learned friend has traveled far beyond what was there in the actual writ petition, my lord, what was pleaded, my lord. My lord, will kindly come to page 78.
Of
This
which
is the
appeal?
writ petition.
Of which appeal?
Yes, my lord. This appeal.
Which appeal?
Appeal 10. The writ appeal 10. All submissions at once is that they are having rights over the reserve forest or forest whatsoever, my lord. And then my lord will kindly see nowhere in the entered petition they have stated under which forest, under which area they have their land. Nowhere they have stated. Although they have annexed the very proposed transmission line. At page 117 onwards, my lord. 1172. This is the entire stretch. 117 to 132. There is completely no leading to the effect that in this stretch of the proposed transmission line, their lane falls in this. What their prayer was initially, not in the writ petition, what they have now just taken a U-turn. They have in paragraph at page 106. First prayer is for setting aside the notice 22/6/2020 / 31/8/2023. And 31/8/2023 is the notification. And then the second paragraph, prayer, my lord, 2A is to pay compensation as per right to fair compensation, transparency in land acquisition, so on so 2039. Then Electricity Act, Indian Telegraph Act, Scheduled Tribes, and other traditional forest dwellers, so on. Then the third prayer is directing the authorities to take cognizance of LPCs pending in the state administration. That is. Then they wanted the suspension of the impugned notification at of 31st August 2029 or 23. Now today, in the writ petition, they were asking for quashing of this. Today, they want to establish their right on the strength of this notification.
Yes, and yes,
They are relying.
he's justifying it through that fresh notification which is annexed in the IA.
Yes, my lord. Now, my lord, I'm coming to that, my lord. My lord will kindly say before page 1111, I'll take your lordship to page 114. This is notification dated 29th August 2019. What it says, my lord? My lord, why I'm trying to differentiate between these two notifications at 1111 and 1114, 114, because they are
So please
reserved
repeat
for
again. I could not follow it. Please repeat again.
these two notifications. Why I am trying to show, my lord. 114 is for forest, not reserve forest. Any type of forest, my lord. Compensation, this will include, my lord. What it says, my lord. The governor of Arunachal Pradesh is pleased to adopt and notify the following rates of payment of compensation towards damages in regards to right of way for transmission lines in accordance with the guidelines of Ministry of Power, Government of India, by so and so, dated 15/10/2015, for maintaining uniformity. My lord, maintaining uniformity in compensation payment to affected landowners during construction of transmission line, it has been decided that a similar payment methodology towards compensation shall also be adopted in the state of Arunachal Pradesh. These guidelines of payment methodology of compensation towards damages as stipulated in section 67 and 68 of the Electricity Act 2003, read with section 10 and 16 of the Indian Telegraph Act 1885 shall be in addition to the compensation towards normal crop and tree damages. This amount will be payable only for transmission lines supported by tower base of 66 kV and above, not for sub-transmission and distribution lines below. Compensation at the rate of 85% of land value as determined by district magistrate or any other competent authority based on government approved rates, circle rate guidelines, so and so act for tower base area between 4 lakes at ground level impacted severely due to installation of tower structure. Compensation towards diminution of land value in the width of right-of-way corridor due to laying of transmission line and imposing certain restriction at a maximum rate of 15% of land value as determined by the Deputy Commissioner, so and so, so and so, so. What I'm saying, my lord, in this 85% and for the land value, which will be for the tower base, and compensation towards that will be for the right of way also, imposing certain restriction at a maximum rate of 15% of the land value as determined by the, because the entire land apart from that base, the ROW, the land is not being acquired. Only the towards diminution of the land value is being paid at the rate of 15%. Now, this notification is under the Telegraph Electricity section 67 and 68 of Electricity Act, read with section 10 and 16 of Telegraph Act. Now, my lord, will see at page 31, 111. These are normal compensation under the Telegraph Act. Page 111, 31st August 2023, notification, my lord. What is this, my lord? In the interest of public service, the governor of Arunachal Pradesh is pleased to notify the special ex gratia relief packages towards right of way for 132 kV transmission line passing through reserve forest under the comprehensive scheme for strengthening of transmission and distribution in Arunachal Pradesh policy for the purpose of facilitating completion of the statewide project for economic development of the state of Arunachal Pradesh under so and so. This is under reserve forest. Then, my lord, right of way for so and so 132 kV transmission line for the tribal population as identified in paragraph 3. My lord, I'll come to paragraph 3 also of the policy, who are not entitled to any benefits, including compensation of specific nature, resettlement or rehabilitation benefits, and ex gratia relief packages amount equivalent to half of the rates notified in so and so dated 2nd September 2019. My lord, which the earlier I was referring. It will be half, equivalent to half the rate of the 2019 notification. This is, although it's at page 114, it is 29 August 2019, but signed on 2nd September at 115. This is that notification. Notification numbers are the same. Payment,
So this would be merely an issue number. Notification number will always come from 114, 29th August.
my lord will see, at page 115,
That is issue number.
issue date.
Issue is 29, but notification date will always be 29/8.
It should be, have been, but, they have put it 2nd September 2019.
It's an issue date.
Yes, but the, notification number is set.
That's okay, but this is issue.
Yes, my
number.
lord. They have put it, instead of 29.
Whatever it is.
No, it doesn't make any difference, my lord. So here, half, my lord, half the rate, what was, has been notified in 2019, the earlier notification. And for the reserve forest, my lord. Now, para 3, what it says, for the tribal population as identified in paragraph 3 of this policy. What is paragraph 3, my lord? For identification of affected individual. My lord, at page 112, my lord. Where ROWs have been duly granted by competent authority in reserve forest area. These are for individuals who have been given right of way in the reserve forest area. Because tribal population, tribal people who have in the reserve forest also, as per the Scheduled Tribe and Forest Dwellers Act, my lord, they have certain rights. Under that, it is where people have been given right of way in the reserve forest area. This notification, this ex gratia compensation will be given to those people only. Now, my lord, I'll explain to this by going to the Scheduled Tribe Forest Dwellers Act later on, my lord. My lord, will kindly see who are the petitioners, who are the appellants here in all, my lord, the petitioners. My lord, will kindly see from page 2. Arunachal Primitive Tribal Forest Dwellers Forum through 1 Sri so and so, age so and so, a permanent resident of Niti Darlong, POPS Sejosa, so and so, and presently residing at B sector near Rajbhawan, POPS Itanagar, Papumpare district, so and so. Then second, age of Mr. So and so, age about so and so, POPS Itanagar, B sector, Papumpare, so and so. Thomas Navam, 34, resident of Mobusa, POPS Sejosa, so and so, given. Then 4. He is also Viraj Songchung, POPS Sejosa. Then the 5th one also, Julie Village, POPS Sejosa, so and so. Now, my lord, these are where they are primarily residing. Under the Scheduled Tribe and Other Forest Dwellers Act, my lord, recognition of forest rights. Who are the people who are entitled to this act? Who are the people entitled to, who are the forest dwellers dwelling scheduled tribes, my lord? My lord will kindly see the definition, my lord, at 2C. To C. To C, my lord.
Yes.
Forest dwelling scheduled tribes. means the members or community of the scheduled tribe who primarily reside in. My lord has 2C. Reside in and who depend on the forest or forest lands for bona fide livelihood needs and includes the scheduled tribe pastoral communities, my lord, who primarily reside in and who depend on the forest or forest lands, my lord. Forest land will include reserve forest also, my lord, the other unclassified forest also. But forest rights means definition E. Forest right E means the forest rights referred to in section 3. But to avail these forest rights, who are the persons entitled to these forest rights? They have to come under the preview of scheduled caste, forest dwelling scheduled tribes, my lord. Now, forest rights, my lord. This 2C is meant for forest dwelling scheduled tribes and 2O will be for other forest dwellers who are not scheduled tribes. 2O, other forest dwellers means any member or community who has for at least 3 generations prior to 13th day of December 2005 primarily reside in or who depend on the forest or forest land for bona fide livelihood needs. Even those who are not scheduled tribes, they who are primarily residing in and dependent on forest, they are also, but it has also have a rider, prior to 13th day of 2005 and at least 3 generations. 3 generation, 1 generation has been calculated as 25 years, my lord. Now, in the writ petition, nowhere they have said that we are primarily residing in this forest or reserve forest or anything. They have taken a stand that we have an LPC. They have not even made a statement that this LPC is under the reserve forest. They could never make such a statement because my lord knows in our state, LPCs are given under guidelines of 1980, my lord. And there is one specific condition to issue LPC is that it should not be under the reserve forest and you have to have forest clearance.
Where is volume? Which volume?
No, my lord, this is a guideline, my lord.
No,
Of
this
1980.
80 act, where is?
1980 guidelines, my lord.
Where is it?
Guidelines, my lord, will not find, but here, my lord, but today a case in single bench, the guidelines have been issued. Annex, my lord, I've seen.
We'll take it out.
We can have today's order single bench, item 22. And my lord, I'll take your lordship to the land possession certificate which they are relying on. My lord will kindly see at page 133. Guidelines. My lord has seen page 133, my lord. I'm getting the guidelines. My lord will see land possession certificate, so and so. Additional affidavit. This is to certify the plot of land measuring so and so situated under CGSA and described below is actually owned by so and so, not so. In the last line, further, it is certified that this certificate is issued for obtaining financial assistance from the Bank of India CGSA branch and not valid for other purposes. Page 133, my lord. And my lord, they have made a statement that this land possession certificate has been issued under the 2006 Act. That can never be, my lord. And they are confusing this honorable court. At page 19, paragraph 6 of the writ petition. The petitioner,
Just a moment.
page 90, which is I. My lord, we'll see.
Page 21, 26.
The very first condition.
तीन बनवा दीजिए तीन बनवा दीजिए appellant को देते बना
My lord, let that come also, my lord. Before that, my lord, at page 90 of this is page 90. This is the writ petition, my lord. Paragraph 6. What they have stated, the petitioner begs to submit that there is complete absence of mention under this notification of due relief to tribal affected by the project having crystallized rights in affected geographical area as per law. This is pertinent to mention herein that the petitioner, namely so and so, were issued land possession certificates in the year 2010 and 2014 in accordance with the provisions of Forest Act 2006. Completely a misleading statement, madam. First, they have to show to avail the benefit of this 2006, my lord, the Scheduled Tribe and Other Forest Dwellers Act, my lord. They have to show that they have a right in the forest land, be it the reserve forest or the unclassified state forest or any other forest, my lord. And that right can be shown, demonstrated, if they are primarily residing and depending on the forest. One cannot here be staying in the capital complex and say that I have a right there. I'm primarily depending on that. No, my lord, that is not the idea to protect. Now everyone wants compensation. That is the problem, without having rights. But as per this 31st August 2023, there may be people who have been given right of way in reserve forest also. At least those persons, they have to be compensated. That is the idea, madam. So, my lord, my first submission will be that the entire argument advanced by the appellant is beyond their pleadings, firstly. Even assuming that they want to struck down the notification of 2023, which talks about compensation for reserve forest, under reserve forest. First of all, they have to show that they are entitled to compensation for under that reserve forest. And to be entitled, they have to again show that they are covered by the 2006 Act, Forest Scheduled Tribe Forest Dwellers. Right. They have to show that they are people covered under this Act, which they have not demonstrated, could not demonstrate. By the LPC, what they have tried to demonstrate by making a statement that the LPC is given under the 2006 Act, the very LPC, the first condition for issuing of LPC also, which my lord will have it. The first condition is itself is certificate from Forest Department mentioning that the land does not fall under the reserve forest. First condition itself. Now, my lords, in paragraph 27, that is page 100. They have not annexed the cancellation or anything, but they have at least made a statement, my lord. Page 100, my lord. May I read that the above certification is a bland exercise of power unsupported by facts and takes advantage of actions or lack of actions by the administration regarding LPCs in the area. Attention is specifically brought to para 3 of the minutes of the meeting dated 29/6/2018. It clearly shows that 287 LPCs were issued and was been cancelled. What it fails to reveal cancelled LPC due to irregularity and not for the whole that was no human activity in presence in these areas, so and so, so and so. LPCs were maybe issued but cancelled, my lord, because they were not now still their LPCs are not even valid, my lord. उसका एक copy दे दो. My lord, it's in office memorandum, my lord. Issue 1988. This one. May I please your lordships? My lord, I'll not take much, my lord. My lord, in the writ petition, while the petitioners were challenging the notification of 31st August,
That is a statement which gives us relief. It will not take much time.
yes, madam. While challenging the notification of 31st August 2023, my lord, which is in respect to reserve forest, compensation in reserve forest, the petitioners were claiming that the notifications, the acquisition which were carried out in two places, that is Passa and Pajariam,
Well,
they
I've
they
not
were
been
being
able to-
deprived.
I'll be not be, I'll not, I have not followed you.
I'll take your lordship,
Yeah.
my lord. Two places, two circles, my lord, that they are deprived of their land compensation. My lord, at page 319, this is 319.
They are saying about Sesoja and Nonera Forest Division.
My lord, now they are saying that, my
Okay.
lord, the earlier notification in the writ petition, the
Page 300.
19. Here, genuine landowners, this was not under the reserve forest, this was unclassified state forest, my lord. Forest area, but unclassified, not under the reserve forest. And this is with respect to Pejirang circle under Pakke Kesang, my lord. The genuine landowners were identified and they were given compensation, full compensation under the 2019 notification.
PJ Rang.
Pejirang circle. Concerned affected persons under Pejirang district. Here, as many as my lord will see, at page 329, 67%.
Sir, just a moment. I will retiring for lunch. I have a map of the state of Arunachal Pradesh. I just looked into it because of this Pakke Kesang and Pakke Kesang and Papumpare are adjacent. And therefore, this I presume that the Pakke reserve is within Pakke Kesang district, and there's a connected forest in the Itanagar section also. That will be because he gave the name of Papum Reserve Forest.
Papum Reserve.
If it is Papum Reserve Forest, I presume it is Papumpare, so it is within the Papumpare district. Am I right or wrong?
My lord, that instruction, I'm also a bit confused, my lord. I have first time,
I'm just
I
presuming.
used
the name of-
to hear about Pakke Reserve, but Papum Reserve,
No, Papum Reserve is there. Itanagar is Papum Reserve. That is the lot of litigations going on.
Papum Reserve.
We have dealt with the Itanagar Reserve Forest in Itanagar.
Yes, Itanagar Reserve Forest, but Papum
No, I'm
Reserve,
just presuming, because you see, Itanagar is within Papumpare district. When the name Papum came, I just presumed that it will be a connected forest to Pakke Kesang. Maybe it is a connected forest. We don't know.
maybe, my lord. I'm also hearing it for the first time, Papum Reserve Forest. Earlier, we used to hear only hear about Pakke Reserve, Tiger Reserve Forest.
No, since I don't know, I'm not
Yes.
saying it conclusively, but
in any
since
case,
the
my
name
lord,
came,
whether it is in
Okay.
Pakke Kesang district or Papumpare district, my lord. My lord, here it is page 319 is for Pejirang Circle District Pakke Kesang, my lord.
Hmm.
And at page 329, as many as 67 landowners were genuine landowners were identified.
in this, how many persons are there?
67.
In the 60,
7.
in 319.
Yes, 319. The last is 329.
Yes.
67. Serial number 67. Table B is given. total landowners 67, total landowners verified 65, then total landowners not verified 60, plot number 66 and 67, dispute on ownership, total dispute on ownership, the plot numbers are given, dispute on ownership. And this was finalized, my lord. These were identified, beneficiaries were identified. Genuine,
Yes.
and then at page 331,
Yes,
this is for Pasaveli.
yes.
Earlier was for Pejerang, and this is for Pasaveli. Here also, my lord, genuine landowners were identified at page 337. Total owners is 72. Total landowners verified 69. Total landowners not verified 3 numbers. Total dispute on ownership, plot number so and so, so and so. And then final identification is 68, madam. Now thereafter, these were recommended on 17 January 2024. And then after, on 7th March, they were asked to collect their compensation, madam. At page 339. In both the list, none of the writ petitioners, they were there. However, in the guise of this compensation verification carried out, they were claiming they have filed this writ petition, 2 writ petitions, many numbers. They were not identified. The actual landowners were identified and compensation paid. But the petitioners cannot act like busybodies, madam. They have to have some definite rights over some definite area, madam, which they have not described in the writ petition. Only a sweeping submission has been advanced that we are entitled to rights under the Forest Dwellers, Scheduled Tribe and Forest Dwellers Act. Now, this again, in the IA, the appellants at page 52, annexure 2. Because transmission line passes through different types of forest. Earlier it was this Pake and Pasaya and Pajerang was unclassified state forest. Now this is a stretch at page 52. This is for the stretch. Order is
52 of the IA.
IA.
Yes.
My lord has got page 52. This is by the Deputy Commissioner, Pakistan District, my lord. What it says, sir. Whereas a meeting was held on 23rd November 2024 under the chairmanship of Chief Secretary, Government of Arunachal Pradesh at Itanagar regarding immediate start of survey and assessment of work in reserved forest areas for payment of diminution cost of land and properties that may likely to be affected due to construction of the 132 kV transmission line under the project. Comprehensive scheme for strengthening soil. The Chief Secretary has instructed all deputy commissioners to start survey and assessment work of tower foundation area and right of way
of 132 kV transmission line in the district and submit estimated diminution cost of land and properties to the requiring agency for payment of diminution cost to the genuine landowners in the state. Therefore, board has been constituted. Then my lord will say copy 2 at page 54. That's serial number 12. Copy to all GBs means Gaumburas of affected village with direction to remain present and verify the actual landowner boundary, etc. in full uniform during survey and demarcation in the field. Now, my lord, even for the reserve forest, if there are certain people who are residing within the reserve forest, their rights are protected, my lord. In what way they are, for what reason they want the stay of this order? On one hand, they want that they have to be heard while the survey is carried out, while assessing any compensation, if they have any right. On the other hand, they are again wanting the stay of this order. The prayer in this IA is for stay of this. I cannot understand what exactly they want. If they have any right under the scheduled tribe forest dwellers, they can go and claim here also. The ultimate prayer before this honorable court is, my lord, give some time to participate. Why did not they participate? Why challenge this? They will carry out, these people will carry out, the board members will carry out, along with the Gaumburas, they will identify the people. Therefore, my lord, to sum up, my lord, petitioners, they have not made out any absolute right. They have not indicated that they have this certain right under the Scheduled Tribe Forest Dwellers Act. The right of any kind of right of property or right of way or anything, they have not been able to demonstrate. Firstly, madam, they have not even demonstrated whether they are having rights in the reserve forest or unclassified forest, madam. Not even that, not even to that extent, madam. Now, whether on the basis of, in the absence of these rights, my lord will call upon to set aside the notifications. They are not affected people. And therefore, my lord, with regard to the adequacy or inadequacy of the compensation for the power grid, my lord, for this transmission line, which is what, as per this notification of 2019, as well as because it's a guidelines, my lord. If I trouble your lordship once again, only at one page, my lord, at page 114. Yes, madam. Why I'm showing this? In 2015, by a notification of 2000 guidelines of 2015, under the central government, Ministry of Power has made a guidelines to have pay compensation under the Electricity and Telegraph Act, my lord, for uniform compensation in all states, because these power lines are passing through different states. For all the states, they have adopted a guideline for uniform compensation. Now that has been adopted in the state. The education and inadequacy, my learned friend from the PGCI, he will explain because showing the relevant provisions of the Telegraph and Electricity Act. My contention is that we are also following the uniform guidelines which the central government Ministry of Power has given by notification of 2015, and we have adopted it. And in 2019, plus for reserve forest also, we have another compensation. This is by way of ex gratia package, my lord. This is in addition, because since there might be people having rights in the reserve forest also, only for that people. That's all, man.
My lords. My lords, if I may, my lords. My lords, I'm representing Power Grid Corporation of India Limited, respondent number 6, in both the rate appeals, being rate appeal number 9 as well as rate appeal number 10. My lord, this would be the
Because you have a long single bench, we'll continue this tomorrow. With your lordship. We will not be able to, otherwise single bench matters will
Yes, ma'am.
remain.
my lord,
How much,
if this
how
can
much
be,
time, how much time you will consume?
my lord, I'll not take more than 20 minutes. If my lord permits, I'll just take my
Okay.
lord to the relevant provision of law.
Okay, we'll continue tomorrow in this matter. You're listing it tomorrow.
My lord, I may be permitted to appear through VC tomorrow.
Yes,
From
yes.
outstation. Highly obliged, my lord.
The submissions of Mr. A. Kashyap, learned counsel for the appellant, is concluded for my reserving right to reply. The submissions of Mr. N. Ratan, the Additional Advocate General. You are also appearing with him?
Yes.
I'm assisting. Additional Advocate General, assisted by Mr. L. Parnell, counsel for respond numbers 1 and 5 to 7. As concluded.
I'm for 6.
1 to 5.
1 to
1 to
5 and 7.
7.
Your name?
In Khera, my lord.
N. Khera, okay. Mr. N. Khera, standing counsel for the Power Grid Corporation of India, for the respond number 6, appears through video conferencing. Next paragraph. For the submissions of the learned counsel for respond number 6 and reply submission by the learned counsel for the petitioner. List as a parted matter on tomorrow.
My lord.
Other matters will be adjourned if there are any.
It's connected matters both.
Huh?
Both
Okay, these are last matters.
connected.
My lord, similar order for both the matters, 6 and 7.
This is common hearing.
Common name.
Common hearing, my lord.
My lord, may I pray item 8, my lord? This matter may be taken off after the puja break, my lord. I have taken consent from the other side, my lord.
But that prayer will be refused. You can't take puja adjournment now.
Oh, my lord. After the ensuing
Viewation.
view-
Okay.
view.
Huh.
petition read.
I have to give versus a repeatment. This sort of revocation is paid for by London Additional Review Journal. Yes, item number
8.
8.
In item 22, my lord. This also maybe after this behavior, my lord. Because they have filed additional affidavit, I have to take instruction.
Okay, same. I hope you have informed the other side.
Yes, my lord. Mr. Pangin, in both cases. My lord, there is an interim order in item 22.
22.
2.
Okay,
In-
22 interim order is from there.
Obliged, ma'am.
Madam, may I mention yesterday's matter, madam? I've corrected it, the fourth list. After matter, the item 4. Deputy.
May I, Your Lordship? Lordship, I beg to mention item number 11, Your Lordship.
You have to take it up. This is a fixed matter.
Yes, Your Lordship. In this matter, additional senior government advocate, Gotterete is appearing. She instructed me to adjourn this matter, Your Lordship.
We will have to see
After-
why this is a fixed matter. If this is a fixed matter, we'll just, you renew the prayer when the matter is called. Consider it then.
And Your Lordship, item number 27, Your Lordship. Here
37.
we have received our paravas reply, so at least we need 2 weeks time to file our counter affidavit.
Item number?
27, item number 27.
Ah,
2 weeks.
okay. This is also fixed matter.
Yes, Lordship. Lordship, in this matter, I am appearing on behalf of the petitioner, Lordship. This matter, Lordship, as a matter of fact, it has been fixed for the consideration of the interim or petition, Lordship. But since they have received the paravise reply today itself.
Let me fix another day after revision.
Yes, Your Lordship.
In that case, Lordship, this matter may be come up
28th.
22nd April, Lordship.
22nd will be too tough because all matters are being adjourned.
Lordship.
25,
Lordship.
both are represented. The Kangul government advocate submitted that she has received paravise comments and would be filing the affidavit in opposition in a week's time. So accordingly, matters stands adjourned today. List on 25, 4/2025. So the learned, Mr.
T. Garam, Lordship.
T. Garam, learned counsel for the petitioner, submits that by the last order, case was fixed for consideration of interim prayer for interim relief. So accordingly, the said prayer shall be taken up on the next date of listing.
Okay. Deeply obliged, Lordship.
Your Lordship, I would like to mention item number 5 and 15. I have taken consent from the other side, government side.
5 and 15.
Yes, Your Lord.
Okay.
This matter may be fixed after 3 weeks.
After 3 weeks, as paid for by the counsel for the petitioner. Okay.
Ma'am, Lordship, with the consent from other side, I beg to mention item number 6, Lordship. Leading counsel P.T. Thara is out of station, Lordship.
6.
Lordship, 6, 9, 10, and 29, Lordship.
6,
9, 10, and 20.
9, 10,
29,
and
Lordship.
29.
Lordship. The list after 3 weeks, Lordship.
Okay, you are for the petitioner or respondent?
Petitioner, Lordship. And item number 29, I am for respondent, Lordship.
In 29, you are respondent.
Lordship.
Okay. both
I
sides
take
are
consent from the
represented,
petitioner.
made by the counsel for the petitioner. In item number 6
9 and 20.
and 9. And in 29, he is respondent. From the questions adjourned today, list after 3 weeks.
Obliged.
Ma'am, my lord. I think to mention item number 16.
on behalf of K lawyer for the petitioner.
1616.
Yes, here, my lord, pleadings are complete. So, whether may fix for admission hearing.
I'm for private respondent number 4.
Both sides are represented. It is submitted that the pleadings are completed. So accordingly, this is the matter after 2 weeks. In the admission column.
May I please, Your Lordship? Your Lordship, I like to mention item number 21, Your Lordship.
21.
Your Lordship, here I am for the petitioner, Your Lordship. Your Lordship, this contempt petition may be closed, Your Lordship, as the department has complied the order.
I will be order. Okay.
I'm appearing to also respondent number 1 and 2, Lordship.
Your name?
K Tabang, Lordship.
Ketabang. Okay. Upon instructions, Mr.
E. Menjo, Your Lordship.
E. Menjo, NENJO, learned counsel for the petitioner, submits that during the pendency of this contempt petition, the order of the court has been complied with. Next paragraph. Mr. P. Kate Tabang, learned counsel for the respondent is present. Respondents is present. Next, upon satisfaction, this contempt petition stands closed.
May I, Your Lordship? Lordship, I beg to mention item number 1, Your Lordship. On behalf of AAG Arish Nabom, he instructed me to adjourn
This
this
is a
matter.
motion matter. This is a motion matter. Motion matter, just let the matter be called.
Well, Lordship, I'm on behalf of Michinibo, item number 13.
13.
We have item number 13.
Item 13 is a fixed matter.
My lord, I have taken.
It was fixed, my lord. We have to file the affidavit. We have filed our affidavit, my lord.
File the affidavit.
Yes, Lord. Matter can be adjourned, my lord.
After, maybe after 1 week.
After
1 week.
Okay. Which was the item number?
13, my lord.
13. Okay. Both sides are represented. Mr. B. Pichal and counsel for the petitioner. Sorry, respondent. You have the state.
Yes, my lord.
The
6 and 7, my lord.
Standing counsel for respondent 6 and 7 has submitted that an affidavit in opposition has been filed. Next, accordingly, on the prayer made by the counsel for the petitioner. Matter stands adjourned today, list 3 weeks. Okay, any interim order is there?
No, my lord.
Okay.
Oblige.
May I please, your lordship? Your lordship, I like to mention item number 12 on behalf of Mr. T. Tapak. Your lordship, in this matter, we will file rejoinder application. Therefore, the matter may be fixed after 1 week. And prior consent has been obtained.
Listed after 3 weeks because 2 weeks are very difficult. It says a represented on the prayer made by the counsel for the petitioner, list after 3 weeks so as to enable the petitioners to file rejoinder affidavit.
Yes.
Okay.
And
if you're listing it after 3 weeks, you please make a mention if it is not listed.
And your lordship, item number 26. This may be also adjourned for today because leading counsel, Mr. T. Tapak is out of station.
Okay, 26. Both sides are represented on the prayer made by the counsel for the petitioner. List after 3 weeks. Okay.
Oblige you.
May I, my lord? I would like to mention item number 7. Conducting counsel for the petitioner, Mr. Pibu is out of station. This matter may be adjourned for 1 week.
7, somebody took an adjournment.
7.
Somebody took an adjournment.
Then I would like to mention this item number 24, my lord.
24.
Pleadings are over. So matter may be fixed for admission hearing.
24.
Yes, my lord.
I mentioned here, like, so, money. Yes, about. Take it. Both sides are represented on the prayer made by the council for the, you are for the petitioner.
I'm for the petition.
The petition, the matter stands adjourned today, list after 3 weeks. Item 7, then second item,
24.
24. Same order here. You are for the petitioner here also? You are for the petitioner here also?
Yes.
Okay.
Your Lordship, I'm for the respondent number 4. I'm for the respondent number 4 in item number 24. So,
You said all sides is represented.
obliged.
Yeah, please, Your Lordship. Your Lordship, with the consent of the council for the opposite party, I'm praying for the adjournment of item number 28, Your Lordship. We need to get some instruction in this matter. Your Lordship.
It's a 2021 matter.
Yes, Your Lordship. Actually, what happened in this case, Your Lordship, this petition pertains to seniority in the department of DRDA. However, Your Lordship, DRDA has been discontinued in the state of Arunachal Pradesh, and it has been taken over by the RD, Your Lordship.
Both sides are represented. With consent of the other side, Mr.
IBAM, Your Lordship.
IBAM, and then counsel for the
Petitioner.
petitioner placed for adjournment. Must already submitted that the seniority position in the DRDA
Yes, DRDA.
was challenged in this writ petition. So however, in the meanwhile, the DRDA has been discontinued, and therefore he wants to have some instructions from the petitioner. So accordingly, matters stands adjourned today. List after
Your Lordship, kindly after 3 weeks.
after 3 weeks. Okay.
Highly obliged.
Yeah, Your Honor. Your Honor, I beg to mention item number 11. Your Honor, the leading counsel is under social restriction due to demise of his mother-in-law recently.
In 11.
11.
Okay. Both sides are represented on the ground that the learned counsel holding the brief is in bereavement. The matter stands adjourned today. List after 3 weeks.
3 weeks, Your Honor.
Any interim order is there?
No. Highly obliged.
May I, Your Honor? I'd like to mention item number 10. For respondent number 8.
10.
Yes, Your Honor. For respondent number 8.
You're for?
Respondent number 8.
Respondent number 8.
Yes,
You're
Your
taking consent?
Yes, Your Honor.
Okay.
I think council is out of session.
Consent of the other side. Then counsel for respondent number 8 pays for adjournment. Prayer is allowed. List after 3 weeks.
With your Lordship.
Any interim order is there?
No, Your Honor, no interim.
You're praying for an adjournment.
Hello, this matter was supposed to be argued by learned senior specially empathy.
So we understand, but motion matter, we had to take it up and then mention in motion matters doesn't look good. I have my reservations in motion matters because prayer for adjournment is made by the government advocate. The petitioner may have some urgency for an interim order, we don't know. So motion matters, I normally avoid adjourning at the motion stage. Okay. Both sides are represented on the and made by Ms. P. Kangal and Council for the state respondents. Matter stands adjourned today. List on.
After vacation, Your Lordship.
This is a motion matter, we have to fix a rate.
Okay, Your Lordship.
25/4/2025.
Oh, yes.
Okay, Your Lordship. Yes.
Motion matter will be good.
Lordship, I beg to mention this matter because I couldn't matter because this is a fixed matter. So I'm praying for adjournment of this matter, Your Lordship. Because the leading counsel is before the principal pensionary, Your Lordship.
Both sides are represented. The claim made by the learned counsel for the petitioner, the matter stands adjourned today. List when?
On 22nd, Your Lordship.
No, 22nd will be difficult. We make it 28.
28, Your Lordship.
28 April. Okay.
Much obliged.
Lordship, this is a compensation matter, Lordship. Lordship here, the stretch of area, Lordship, belongs to the father, is ancestral property belonging to the father of the petitioner. The same was even decided by the learned additional district judge, Basa.
You see, I have a reservation in entertaining a repetition like this. You because you see, we can't give a direction, the court cannot give a direction, but we can restrain them from taking over your land.
So the work has already been completed. They have completed the work. Now only direction to assess the damages and pay for compensation. I have also made a complaint when the construction was going on in page number 38. To the chief engineer. And after the completion of the work, again, I have given the representation that is on page number 40.
I told you we would not be able to follow it. You see, you're in your page 38.
Yes.
Your allegation is that the boulders have been stolen. Correct?
Yes.
So can the court without an adjudication say that the compensation for stolen goods?
Lordship, that boulders are secondary. Main is my land. The construction was done in my land without my permission. By the work was given by the government, the respondent authority, specifically respondent number 3. Anti-erosion work.
But look at the representation. Further, without carrying out valuation of the boulders stolen by you and your contractor, and without determining the value of the land forcibly disturbed by you, no bill whatsoever may be paid for the work to the contractor.
This was made when the work was going on.
But then
and now the work has already been completed. And again, I have made a representation to the chief engineer on page number 40.
This is something you see, I have a reservation because of the language used in these representations. Same thing here. Here also, your first prayer is that you do not pay the contractor. Correct?
Yes, sir.
Now, second is, you also say that if you don't, if any bail is paid, then I will construe it for the illegal and despotic act. And then you make a prayer that for my land acquisition.
Since they have taken the land is a private land, and the construction they have done without taking permission from the petitioner, and without even acquiring the land.
But who is given a where is your land holding certificate?
My land, the stretch of the land, page number 35 is the map of the land.
It's not map. You see, the map is one part and the land holding certificate is another part. Who has declared the title in your favor?
This land was given to me by title was given to me by additional district judge. No, so page number 33 is the operating plan. It is an ancestral property, though there has been dispute and the additional district judge has conferred the title to the father of the petitioner in the year 2008.
I'm not being able to find the description of land here. In this order, I've been trying to read it. Can you show me where is the land described?
Worship, the disputed land, Remy Morang from page number 33.
33. Yes, disputed land, Remy Moran. Now, which is this land here? No, sorry, I'll be dismissing your petition, but I'll give you liberty to approach the authorities for compensation. Direction to acquire land is just not maintainable. A writ petition to acquire land is not maintainable. At best, when your land is damaged, you can seek compensation for damages. Damages you are not asking.
Lordship, damages acquired along with damages also, Lordship. But since in the Lordship, the representative page number 41, I have stated, Lordship, that there is a spray that the story that the tribal land creating structure, the damages has been done by creating structures in my land.
But you are not seeking damages. You see, it's a simple proposition.
Yes.
If you are saying acquire this,
Yes.
but if I have caused damage to this, when I acquire this, the damages will be inherent. It is my property then. State will not give you damages and then acquire the land. Got it?
Yes, Lordship. The damages has all done.
Damage, if the land is acquired, the damages is of the person who has acquired it. You can't get two compensation for land acquisition and for damages. But for writ petition to mandamus to direct land to be acquired, that can't be issued.
Listen, this area was private land, which because of the government, they have given a work order on that land, and the damages were done during the construction of that work, on execution of that work.
Well, you can claim damages. This is civil court, but this petition for direction to acquire, it's not possible.
In that case, Lordship, kindly direction to dispose the representation.
No. Disposal of representation business, I will not be inclined to pass orders. I am good in giving horrible examples. Can I give you one? You search your mobile, the Google you search, and you'll find that youngest boy to be a police commissioner. You'll get it in Rajasthan. Just check up, it will be interesting. Youngest boy to be commissioner of police. Commissioner of police or deputy commissioner, I forgot. It happened about 8 to 10 years back. A young boy who was suffering from terminal cancer. Terminal disease, cancer is not there in Google, it's not coming. He was suffering from a terminal disease and he expressed his desire before the government of Rajasthan to make him a police commissioner for a day. And police commissioner, deputy commissioner, I forgot. And the Rajasthan government acceded to that. And this young boy, who was a minor, became a deputy commissioner for a day. Or what do you call, police commissioner for a day. Now, with that in mind, I want to say that, well, I have very limited time in service right now. Therefore, I have a dream that I should walk to moon. And therefore, I have given a representation to the government. Please construct a staircase from or a road from Earth to moon. I want to walk and go. And then I come to court and say that I have given a representation, please dispose it of. Correct. So representation business, I'm sorry, I'm not in.
So here's the
If I decide that you have a right, then I will declare that right and then say dispose of representation. I'm sorry.
No, so the necessary.
Mr. T. Gyasto, the net counsel for the petitioner. Next paragraph. Sorry, also had Ms. T. Rango, the government advocate appearing for the respondents. Respondent numbers. All the respondents.
One, respondent number one.
Only one. Who is for 2 and 3 then? This is government.
No, Brahmaputra board.
Brahmaputra board is government. It's not state government.
Brahmaputra Board.
Okay, it's 101. Next, in brief, the case of the petitioner is that he has a lot of land near Remi, R-E-M-I, river. What's the name of the river? Remi, R-E-M-I, Remi river. And over this said land, the respondent authorities had given a contract wide work order dated 23/3/2023 to a particular contractor for the work of inverted commas for construction of inverted commas anti-erosion work along Remi River bracket protection work at Mirem M-I-R-E-M village comma Minglung M-I-N-G-L-U-N-G Minglung village and Remi village in East Siang district comma Arunachal Pradesh inverted comma closed. Full stop. The petitioner alleges that without acquiring his land, the respondent authorities, by using heavy machinery to mine stones and boulders belonging to the petitioner, had illegally carried out the said anti-erosion work. Full stop. In this respect, the petitioner has submitted representation dated 13/1/2025, 4/4/2025, to the respondents stating that his boulders were used for the work without determining the value of the land. First of all, apart from praying that no bill whatsoever should be paid to the contractor, the petitioner had also prayed for a proper land acquisition to be carried out and thereafter compensation in respect of the said land be disbursed in terms of the acquisition laws. Next, as those representations were not acted upon, the present date petition has been filed under Article 226 in the Constitution of India. Next, in this regard, the court is of the considered opinion that insofar as direction for issuance of writ of the mandamus to the appropriate government to acquire the land cannot be issued. Because no legal and fundamental right of the petitioner is aggrieved if land of the petitioner is not acquired. Next, however, in the event any damage has been caused to the land of the petitioner his right to agitate against the respondent for damages caused. For which the petitioner has liberty to approach the civil court for claiming damages, if so advised. The observations that indicated above, this petition is closed with closed at the motion stage without issues or notice of the respondents.
Thank you.
Matter. What matter pertains to cancellation of NIT, my lord? Initially, my lord, in terms of an NIT dated 8/1/2025, the petitioner was found to be the lowest bidder. Thereafter, they cancelled it, no reasons whatsoever. Then they floated another tender that was for on ad hoc purpose only for 2 months. Then they floated another tender, impugned tender now NIT. And thereafter, they have submitted reasons saying that my price bid was way too high, with the cost grade loss to the state exchequer. But I submitted a bid that was 12% lower than the estimated cost put to tender, my lord. The whole reasons, my lord, given was totally arbitrary. Your lordship may kindly have page 52.
52. You are saying that the tender was cancelled.
Yes.
Then
Cancelled, and ultimately they gave me a reason. They wrote me a communication saying that I was the lowest bidder. They said my tender was cancelled because the price bid I submitted was way too high. Whereas my price bid was 12% below the estimated cost per tender.
yes, it should be 50%.
Yes. We're saying high, my lord. You will go loss to the exchequer.
Your bid should have been 50% of the estimated cost.
Madam.
12% is high.
Yes. But there is an estimated cost, madam.
I don't know.
Yes.
Even minus 10% can be high.
Yeah.
Mr. Kato would be expecting minus 50%.
Maybe, madam.
Maybe.
Well.
Where is that page?
Your lordship may kindly have page 52, just for the
52.
purpose of showing, my lord. I have not bothered lordship with very much. Page 52, my lord, annexure
But
140.
when it was opened, definitely you were there and the comparative price is available with you.
Hello?
When these bids were open, definitely you were there and you know the comparative statement of the bids.
Yes, yes. My lord, they do it online, my lord. On after scrutiny, my lord, they have uploaded it online.
Page 52.
Page 52 is the, my lord, the NIT, my lord. Only 2 columns now that I am showing, name of the work. The name of the work is road transport contract such and such from Bandardua to FSD Coloriam versus such and such on regular basis, my lord, kindly note that. For a period of 2 years.
Yes.
Then my lord will have the next column, the estimated value of contract is 3 crore 65 lakhs 75,000 only. 3 crore 65 lakhs 75,000 only. That is the estimated cost put to tender. Now I'm not bordering on the other documents. These are the bits that I have submitted. Now, but only one thing I'm going to point out, my lord, this was supposed to be open on 29th of January. That your lordship will find at page number 57.
Five seven.
Yes, 57. This is part of the NIT. My lord will, just before the last para, with reference to the said tenor, the following relevant date may be noted.
Yes.
Last online technical bid opening date, that is 29/1/2025. I am showing this because the document we have downloaded from the website is not very legible, my lord. Then your lordship will kindly have page 165, my lord. Annexure 4.
Yes.
My lord, will see this is we have downloaded from the website. There are 5 bidders. I am at the last, my lord, serial number 5, Messrs. TT Enterprise.
Yes.
I, along with 2 others, have qualified the technical bid. Two have been disqualified, so 3 have qualified.
Yes.
Then, lordship will have the next page. These are all on 29th of January.
Yes.
My lord will see my name, serial number 1, Messrs. TT Enterprise, L1. Lowest tenderer. My bid is 3 crore 20 lakh something. Where the estimated cost put to tender was 3 lakh 65,000, 65 lakh 75,000.
Yes.
Then, my lord, on the very next page, on the very same day, that is on 29th itself, my lord, the status is shown as cancelled. No reason, nothing given to me, man. I was the lowest bidder. I have some legitimate expectation. Then, my lord, from Annexure 7, my lord, this is the representation I served to the authorities, submit to the authorities for reconsideration. Then, my lord, will have page 169. This is, my lord, another NIT. My lord will see the name of the award. Your lordship will see on the difference is. This is for the same route. Road transport contract, exercises Bandar Road FSD Colorium via Waves on ad hoc basis for a period of 3 months. So only for ad hoc basis. Very well, my lord. I put it to challenge, my lord, but ultimately no interim order was granted. Thereafter, my lord, the impugn NIT has been floated at page 224. 224.
Yes.
Name of the award, one is the same, my lord. Estimated cost value of the contract is also exactly the same. This is the same work, my lord.
Yes.
Then, my lord, will see the reason at page 237 why my earlier bid was rejected. Last page, my lord, 237.
Yes.
With reference to your letter dated suspension, it is to inform you the rates cited by your firm in the financial bid were very high. And awarding the contract at the rate would have caused huge financial loss to the government exchequer. I submitted bid of the estimated cost is 3 crore 65 lakhs. I submitted bid of 3 crore 20 lakhs. If this is the reason, my lord, there are 2 other lower bidders, my lord. There are 2 other bidders. My lord, cancellation of tender, my lord, it is within their domain. I understand that, my lord, but it cannot be done in an arbitrary manner, my lord. My lord, see the
Your
sequence of
remedy
events.
lies for claiming compensation.
That is there, my lord. NG projects, my lord, I understand this is creating a hurdle for all of us. But NG project has been clarified to the extent that when the, my lord, state actions are arbitrary, my lord, then, my lord, your lordship can always interfere. Good grace, my lord. Why would they do that, my lord? 8/1/2025, that is the month of January, the same work. I submit a fair bid, my lord. Then they go for ad hoc. Then they again do it, my
You
lord.
see, But once they have cancelled,
Yes.
then we can't turn the clock back.
I had put that to challenge the matter. I put that to challenge. I put to challenge the present NIT also. If your lordship permits, my lord, may I place one judgment, my lord, regarding my lord cancellation of tender, my lord. 1993. This is also of FCI versus MS Kamdhenu, Motors Kamdhenu Cattle Feed.
Kamdhenu is almost diluted.
My lord, yes, my lord, this is a three-judge bench, my lord. It's a three-judge bench. NG project is my lord, two judges. And NG project also has been clarified to the extent if there is something arbitrary, my lord, your lordship can always exercise.
Because before this NG,
I understand, my lord.
NG, before that there was a judgment of three-judge bench again. Yes.
Yes.
Show it.
NG project. Kitab Janan.
Because this NG projects was preceded by another three-judge bench. After that only.
NG projects were, if I am correct, you call it two judges bench.
No, before that. After that only NG project come.
My lord, we are all aware, my lord, there are so many judgments regarding tender matters, my lord. Ultimately, if your lordship finds it arbitrary, nobody can tie your lordship's hands. This way, that way, my lord, there are various. See, even Jagdish Bandal says, if it is arbitrary, your lordship can, my lord. And if I can show on the face of it, because they say, your bid is so high, that is the reason granted, given, my lord. But my bid is 40 lesser than the estimated cost.
He has an answer.
I hope so. I just rely on one paragraph, my lord. Paragraph 10 only. 7, 8 pertains to legitimate expectations, my lord. 10 only I am reading, my lord. From the above, it is clear that even though the highest tenderer can claim no right to have his tender accepted, there being a power while inviting tenders to reject all the tenders, yet the power to reject all the tenders cannot be exercised arbitrarily and must depend on its validity on the existence of cogent reasons for such action. What I am submitting, my lord, is the bids are supposed to be open on 15th, my lord. If they can, my lord, before that so, that these are the reasons, my lord. Because of the face of it pays 237. If they say it will cost huge loss to the state exchequer, my lord, I can imagine, my lord, are they saying that I should submit the unreasonably low bid, my lord? So lordship was suggesting, my lord, maybe 50% less. Take it to Koloriang, my lord. The road condition is horrible.
Yes.
I'm the one, always facing difficulty. Sometimes I used to stand that side, now, and here again, the respondent of the all petitioner, in every petitions, the petitioners made Union of India as one of the necessary party, but there is the everything has been done by the other respondents. So therefore it is
But you appear for FCI also, no?
No, FCI, they have their standing counsel,
Who is he?
Here, one Guwahati-based lawyer, I don't remember the name.
Earlier, here also they used to be standing counsel. I don't know now.
Do you serve copy to him?
I am for the respondent number 1, Union of India only, So therefore, that is the one difficulty, always I am facing.
But if there is standing counsel, then we can't.
There is no standing counsel in respect of this bench.
Yes, that is true.
Huh?
No respect of this bench, not anymore.
Guwahati-based
Earlier,
lawyer.
Mr. Sakia was there, then Miss Sangeeta was there, they are no longer there.
And even if we come to the merit of the case, even sometimes it is the CBC guidelines. The L1 has to be always considered, and there is no provisions for the giving the award, the giving works to the second L, third L. There is no as per the CBC guideline, if
No, because you see, the submission of if we can. In my usual tone.
Regarding the estimated cost.
No, that in my where is that bid you showed us? Comparative statement, page 52.
NIT, my lord.
No, where is it comparative statement?
Comparative, my lord, page 166, my lord.
Comparative statement as such,
It
they
is-
have not given, they have only given, this we have downloaded from the
Where is that?
166.
166, annexure 5, my lord. As per this price quoted by the
yes,
my lord petitioner, it is fair, my lord.
40 lakhs less.
It is-
66.
Yes.
44 lakhs 78,000, my lord, minus.
We understand. But I would think in a way that if P crore 20 is high, why they can't give it to the second person whose bid is low at 3 crore 79 lakh? Or to third whose bid is 4 crore 36 lakh? If 320 is high, 4 crore would be low.
My lord, to make fair submission, my lord. That is the my lord difficulty in my lord.
You are right, you are right. And Mr. D. Pani, learned counsel for the petitioner, as well as Mr. M. Katul and a DSG appearing for respondent number 1. Next, the learned DSG has submitted that he is not instructed to appear for the Food Corporation of India. First off, on a query of the court, the learned counsel for the petitioner, as well as the learned DSG has submitted that the respondent numbers 2 to 6 by the Food Corporation of India and its in its officers. You don't have a standing counsel in for this bench for the time being. Next paragraph. In brief, the case of the petitioner is that he's a transport contractor and in response to a notice inviting bid in respect of tender number, page 52. Tender number so dated 8/1/2025 in respect of the work of, this is down below here. He had participated in the tender along with 4 other bidders. First off, the estimated value of contract, as per the NIET. NI is capital, E small, E capital. NIET was rupees 3, 65, 75, 000. And as negative bidding was permitted, the petitioner had submitted a bid price of rupees 3, 20, 96, 520.00, whereas and was adjudged as L1 bidder on
This was on
29/1/2025, or the date when the bid was opened. Full stop. Next, it is submitted that the L2 bidder, now, as per the downloaded statement, the L2 bidder had quoted a rate of rupees 3, 79, 97, 379.99. And the L3 bidder had quoted the bid price of rupees 4, 36, 71, 150.00. However, on the same date, i.e. 29/1/2025, the said bid was cancelled. By an RTI application, the RTI replied, the assistant general manager within bracket contract on behalf of the general manager within bracket R bracket closed FCI, regional office Itanagar, informed the petitioner by a reply dated 5/4/2025 that the rates cited by the petitioner's firm in the financial bid were very high, and awarding the contract at the rate would have caused high financial loss to the government exchequer. The petitioner was further informed that the L1 rate of ad hoc tender was far low than the one quoted by the petitioner in the said regular tender. Next paragraph. The learned counsel for the petitioner submitted that there was no tender condition that the bids submitted should be justifiable from another type with regard to another tender. Accordingly, comment is submitted that when the bid price was rupees 3, 65, 75, 000, the bid submitted by the petitioner for a sum of rupees, for a bid price of rupees 3, 20, 96, 520.00 could not have been adjudged as too high. It is submitted that in respect of the same work, for exactly the same work, another NIT was published on 25/3/2025, which also contains the estimated value of contract at rupees 3, 65, 75, 000, which is exactly the same as it was in the earlier cancelled NIT dated
8/1/22.
8/1/2025. Accordingly, comment is submitted that if the justifiable rates were to be in terms of the ad hoc NIT, which was published on 21/3/2025, then the rates quoted in this subsequent tender issued on 25/3/2025 is irreconcilable with the ground on which the tender of the petitioner was cancelled and adjudged as as too high. Next one. Although the learned, issue notice returnable on 23/4/2025. First, the petitioner shall, as the learned DSGR is accepts notice on behalf of respondent number 1, comma, requisite extra copy of the petition be served on him in course of within 2 days. Next paragraph. The petitioner shall take steps for service of notice on respondent number 2 to 5. 2 to 6. 2 to 6.
Six.
2 to 6 by email, by submitting a written up notice along with scan copy of the tender, scan copy of the petition to the registry, post of the registry upon processing the notice shall hand it over to the learned counsel for the petitioner for service on the respondents through the email address which is provided in the notice inviting e-tender, being SRNAR. This you'll get it page 224. SRNAR dot FCI@gov.in. Give a semicolon and AGM CONTAR full stop FCI@gov.in. First of all, while uploading, while transmitting the said process notice in a scan manner, the learned counsel for the petition shall also attach the scanned copy of the rate petition. Next paragraph. The learned counsel for the petitioner is paid for interim relief, which is opposed by the learned DSGI. Next paragraph. Having considered that the price bid of the petitioner for an amount of rupees 3,20,96,520 stated to be too high in the NIT dated 8/1/2025. Though in the NIT dated 8/1/1995, the estimated value of the contract was rupees 3,65,75,000, and that in the subsequent tender for the same work, issued on 25/3/2025, the estimated value of contract is still maintained at rupees 3,65,75,000, the court is inclined to stay the finalization of tender dated tender number is 224, number so and so, dated 25/3/2025 till the next date of listing. Next paragraph. The respondents, however, given liberty to move the court for modification alteration of the order, or am I so advised?
I did.
But you have seen the order.
Yes,
You
yes,
have
I-
to give a written
Yes, yes.
notice, scan it.
Yes.
Along with the
And-
writ petition, you will have to scan and send it.
And additionally, if your lordship permits, respondent number 4 and 5 are based here. When if your lordship allows justice service, these two will serve here.
Okay, you just add there after e-service, yeah. In addition, the petitioner is given liberty to serve notice on the respondent numbers 4 and 5.
4 and 5.
Who are located at Itanagar
Yes.
by Dastimot. By routing the process through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing.
Okay.
Yeah. This book. Mr. Panging. Your friends, yes, has gone from there to here.
Yeah, yeah. No wonder my lord is not objective.
Well, this is the difficulty I pointed out now. My please, this issue is very limited, madam.
Yes.
The NIT was plotted on, madam, as per the press note, it was on 12 March 2025, madam. Lordship will find at Annexure Annexure 2, page number 14, madam. This was issued by the executive engineer, madam, respondent number 4.
So page
14, madam, 14.
14.
Issued on.
Yes, just.
Madam, I'm sorry. One for them.
Yes.
Press tender notice, my lordship will find the date at right corner top mail. 12 March 12/3/2025, madam. It was issued by the executive engineer. Madam, this NIT was published in the newspaper, madam, which is not common at all, madam, in the city. Uncommon newspaper, madam. There is 3-4 types of newspaper published in the daily, published in the weekly, and published in the fortnight, madam. Now, still we don't know when it was published. But, madam, this is press note given by the department for publication on the newspaper, which will be basically published on next date, madam, 13 March 2000. Now, madam, as per the these notifications, madam, it is published, working, madam, if lordship see the same annexure just below, madam. Availability of bid
Which
documents.
page? You're referring to which page?
I'm reading, madam, same page 14, madam.
114, yes, yes.
The availability of bid documents and the mode of the submissions. The bid documents is available in the office of the executive engineer, PWD, Sagali Division, RWD, Papumpari district, up to 1600 hours on working days from, madam, 13. This is the main reason, madam, I have pointed out, madam. 13 March 2025 to 15/3/2025 on payment of cash non-refundable as mentioned in the column 10, being the cost of tender documents. The bidder are requested to submit original registration certificate along with the domicile certificate to the executive engineer RWD Sakali at the time of the purchase of bid documents. The bidder shall furnish as a part of the bid earnest money for the amount specified in the column number 4. The earnest money DD at the cost of the tender cash shall be in the paper of the executive engineer rural works department so and so. But what I wanted to point out is it was basically effective from 13 March 2025 and closed on 15, madam, only 2 days, madam, time. Now, madam, 14 was holy. There is no, madam, the official, madam, on this 14, madam. Next, madam, 15 is also, madam, the Saturday, madam. This was, madam, done in the manual, madam, e-tender, manual tender, madam, not the, madam, e-tender, madam, e-procurement. Now, my lord, as per the guidelines, my lord, as per the my lord, general finance rule, if my lord, the amounts are my lord, above 2 crores, it has to be my lord, minimum period has to be my lord, 14 days. But amount put to tender is 5 crore,
Where
4
is,
lakhs.
where is that?
My lord, if lordship, perused my lord, the annexure 5, page number 17,
Annexure 5.
my lord. Extract copy, my lord. This is the CPWD manual, how my lord, this is to be done, my lord.
Yeah.
Annexure 5, page number 17. My lord, this is the publicity of tender. This is extract copy, my lord. My lord, next page, page number 18, point number 17.5. Time limit for publicity of tenders, my lord. My lord, I'll skip the rest, my lord, subsection. 14, my lord. Close Roman 3, my lord. 14 days in the case of work with estimated cost put to tender more than Rs 2 crores. Minimum period is prescribed is 14 days. But in our case, even not
What is the last date of submission of tender?
15, my lord.
15.
15, my lord. Saturday.
Oh.
So, and another, my lord, this
Yes,
is also.
Yes, Mr. Tarak.
My lord,
It is published on 13 and it has to submit it by 15. Then this tender is designed only for that person who has everything ready. In one
it
day.
seems to be but my lord, in interpleading. Petitioner have neither said that because of this, he has been debarred from participating. Nothing of that sort. Because of short duration, he could not participate. There is no any pleading. Only here, even in only seeking for fresh tender. So there is no any government.
Obviously, my lord, I am debarred, my lord, because of this sort.
He has not
Yes, my lord.
No, there is no pleading. Mr. Tarak is right. He has found out.
But my lord, my period is for my lord, NIT.
My lord, otherwise, same page 18, 17.52. It says the above time limit may be varied at the discretion of NIT approving authority, keeping in the
No, but this is when 14th is a holiday. Then your justification is not there.
Yes.
It's just his, he has missed out to say that. But Mr. Kato, this is fatal if he is not pleaded. We can really do nothing.
I'm sorry, that part, my lord, I admit, my lord. And my lord, e-procurement, my lord, even e-procurement, my lord, as per the general finance
If it
rule.
is wrong, you can now lodge an FIR. So this was not followed. But that there is a different process. You can file a, this is not a PIL.
Correct.
You can't do anything. I'm sorry with all that trouble. You'll have to close your petition.
My lord, in that case, my lord, may I present, my lord, I may be allowed to withdraw with the liberty to file a press, my lord.
Okay. Next, at the outset, Mr. G. Tarak, standing counsel for the RWD, has submitted that the court would consider that in this petition there is no pleading that the petitioner was prevented from participating in the tender process. I don't say that, otherwise he'll be prejudiced. You just say on the Mr. M. Katul and counsel for the petitioner submits that there is formal defect in the writ petition and therefore he pays permitted to withdraw the writ petition and to approach again. That's why Mr. G. Tarak, standing counsel for the RWD, representing the respondents, is present.
1 to 4.
For 1.
1 to 4.
All the respondents have said. Your 1 to 4 only.
Yes, on to.
Always.
Respondent is 1 to 4. Is it?
1 to 4.
So here is a lot. Matter stands closed on withdrawal with
Well.
liberty as paid for.
Development.
But I appreciate Mr. Tarak. I appreciate your hard work.
I'm sorry, Malad. That was the. Macha.
My please, Lordship. Malad, this is also tender matter, Malad. Here, Malad, this is tender is regarding Malad, vibrant village program, Malad. Construction of road. First of all, Lordship, kindly page 37, Malad. This is the tender notification.
Yes.
So, Malad, 5/7/2024, Malad. This date may be, Malad, kindly be marked because I will be referring this date in some other that one, Malad. Document 5/7/2024.
Yes.
So, Malad, but the open the Malad technical bit, Malad, and you'll also will find that technical bit opening at page 121. 121.
121.
One, two, one. Lordship.
Yes.
Yes. And page relevant portion is, this was open on 2nd August 2024, Lordship. And page 122, next page. This is the result, Malad. Evaluation of the Lordship. 122.
Yes.
Yeah, evaluation 6, Malad. Evaluation B, next, second paragraph. So my name is Malad, serial number 4, Lordship. NT agency.
Yes.
Non-responsive. Attracts 4.4B, Lordship. 4.4 capital B, small b, Roman, small Roman 1. 4.4B, capital B, small b, Roman 2, and 4.7.1. 4. It says, Lordship, I have to have technical manpower and all that, my lord. I'll just, if Lordship, it's the clause is for page 42, but I'll just read for Lordship's. It says, Lordship, the bidder must produce money. Lordship, page 42. Capital B, then small b, my lord, 1. Each bidder must demonstrate availability for construction of work either own or on lease or on hire of key equipment stated in appendix of ITB, including equipment required for establishment field laboratory or perform mandatory tests and those stated in appendix to ITP. These are there, my lord. And small Roman tool, availability of construction work of technical persons as stated in appendix to ITB. One is construction work machineries, and two is
I'm not able to follow you. Which page you are saying?
page 42, Lordship.
42, yes, clause.
For 4.4B.
B, yes.
Yes.
B for Bombay.
B for Bombay, my lord.
Availability of construction work.
My lord, then Lordship, first is A, second is small b. My lord.
Yes, I got it.
And small b is small Roman 1. My lord.
Yes.
Small Roman 1 and Roman 2. This Roman 1, small Roman 1 is equipments. One has to have equipments, that's there. And so small Roman 2 is we have to have technical personnel. These two persons, according to the respondent authorities, I don't have this two, my lord. Or it's short.
4.4.B point.
4.4 capital B, my lord.
The page you are showing is 121.
121, that's yes, the result, lordship. There it is written, lordship, in right side.
121.
122.
First is 4.4B1.
Yes, lordship.
That means B1 that you don't have owned or leased or hired key equipments.
Yes. Yes. My second is technical manpower, small Roman 2. And 4.7, my lord, it says that even if I have everything, my lord, so I'll just read 4.7. The next, page 44.
Yes.
Even though the bidder meet the above qualifying criteria, they are subject to be disqualified if they are made misleading or false representation in the forms, statements, affidavit, attachments submitted in proof of qualification requirement, or
okay, now I remember. Mr. Tarak was saying that you have litigation history.
No.
This is not that case.
No.
Some invoice which they furnished was fake,
Yes.
according to us.
Yes.
No, I remember one of the cases 1 or 2 days back, you said that.
Yes, one of the case was also pending. He have filed case against the department. That also he has not published.
This was NT, correct?
Yes.
On that day, this matter was moved was NT.
NT, yeah.
Okay.
So these are the grounds, man. So, lordship, what I have in this writ petition, I have shown the machineries, technical manpower, which I have uploaded, which starts from page 124 onwards, my lord. And I have, I'll just shorten it, my lord, because why I said I have this, I have uploaded this technical machineries. I have uploaded technical manpower. I have annexed, my lord, which it was in the web, my lord, portal, my lord. I have uploaded. And I also have said in my writ petition that other participants who were declared as a responsive, they didn't have this equipments, that equipments, all allegations I have made, my lord. Ultimately, my only point was that even though they had defects, now I don't want that they should be disqualified. That's not my case, madam. I'm not saying they should be disqualified, but I'm saying in this writ petition that I must be qualified, madam, in the technical bid. Why, madam? Same set of documents, tenders issued by the same authority, regarding the same project, madam, I have been qualified. How there can be two, madam, yardsticks for same construction work, same documents which I have submitted. In one, I have been declared responsive, other non-responsive. How that can be the criteria, madam? If I was not qualified, but I wouldn't have been qualified in that other work also, madam, issued by the same authority. If the authority was different, I would have understood, madam. And the date of tender, that's why I lordship mark this, kindly mark the date of tender, madam. In the other tender, same date tender was issued. I submitted same documents before the same authority, and I'm qualified, madam. If I'm not qualified in this manner, how can I be disqualified in another tender? Lordship may kindly see that.
Where is your statement in the writ petition?
Yes, I have annexed that one.
No, where is the statement
Yes,
in
yes.
your writ petition?
Yes, yes, I've made categorical statement, madam, and they have not answered that also. They have evaded to answer that one.
Where is that?
Paragraph 23, Lordship. Categorical statement. Para 23. Page 18. May I read, my lordship? That humble petitioner begs to bring into kind notice of this honorable court that the respondent author is based on the same set of documents submitted a petitioner for similar tender work under the respondent number 3 pertaining to such and such a road, found the bid of petitioner responsive by bid evaluation dated such and such. Same set of documents. If I would have, they have not denied that one. And lordship will find that evaluation in the last month almost page 320, lordship, almost annexure 18. Lordship will consider 320, lordship.
You've seen that.
Lordship. Kindly see mark the date of tender of this one. Notice invited traders 5/7/2024, madam. Tender notice was also issued on the same date. (320).
I have to rise. Is a division bench.
Yes, Malad. Malad, that's why I'm summing up my Malad. This matter, Malad, but I'm submitting Malad. This different yardstick would not have been applied by the respondent authorities, Malad. So what I'm praying in this one is in this repetition is, my lord, same set of documents when I have qualified in that tender, how the same set of documents I will be disqualified in this tender, madam. So what I'm submitting is praying before this honorable court. Let the technical evaluation that declaration may be set aside and quashed, madam. My tender paper, the price bid may be open, madam. Thereafter, respondent authorities have all the discretion to, madam, decide further also. They might not qualify me there in the price bid also, madam.
This is of, you see, this is bit of 5/7/24.
Yes.
It must have been finalized by now and work must have started.
Yes, that's why.
Work is already
That's
started.
regarding this one, Malad, work has started in the March. This March is not even 1 month. That's why I'm in this case. That's why what I'm submitting is, Malad, even if the work has progressed, Malad, let there, because your lordship will be not be directing the respondent authorities to award me the work, Malad. What I'm praying.
No, that can't happen.
No, that's why what I'm
because if somebody is doing the work,
yes,
by your technical evaluation or the financial bid opening,
yes,
if you are declared, supposing tomorrow you are declared lowest, then what happens?
Let the respondent authority take appropriate decision, Malad, thereafter.
But then there are several judgments which says that you can't stop the project midway.
No, but
then you'll have to only go to the civil court and
yes,
for the.
that's why I'm categorically submitting, Malab. March only started, Malab. If the tender construction what had started earlier, matter would have been different. But I'm praying before this, at least within 7 days or 15 days, let the authority decide, Malab, open the price bid and take appropriate decision, Malab. But in this manner, man, I cannot be disqualified.
Once tender process is over.
Once this is over, you can only give you liberty to approach the civil court for compensation.
But the decision lordship has seen, man, this is total arbitrary, man.
Yeah, but
The manner lordship definitely interfere when there is arbitrariness, man, apparent, man.
no, but you see, for that, if at best you see, the reason is that even if you say so,
yes,
we actually have to look into the tender papers and examine whether in the earlier tenders the same set of documents are there or not.
No, they have not denied, man. That's why. Man.
But they have not denied, that's okay, but satisfaction in the court has to be recorded. You produce the scanned copy of the records of both the tenders, uploaded tenders.
Regarding respondent, I'll try to get it.
No, the petitioner is the other tender, where he says that on the same set of documents you qualified
Okay.
in.
Then I have to get that. Yes.
Get it, we'll fix it on 22nd, this matter. The learned counsel for the petitioner has submitted that Mr. P. Chappell, learned counsel for the petitioner, has submitted that on the same set of documents by which the petitioner was held to be technically disqualified in connection with NIT number, which is that number where we find tender number.
And the first one, Malachir. First
Yes.
one is a page NIT number, Malot. RWD, page 37, Lord.
Page 37.
Yes.
Page 37. Same set of documents is submitted in respect of tender number so dated 5 cents. While the petitioner was disqualified on the same set of documents which was submitted in tender number. Where is the next tender?
Page 320, Lord.
320.
Yes.
Submitted in tender number, page 320. Number so and so. The petitioner was adjudged as the lowest, was adjudged to be technically qualified and was awarded with the work.
Yes. Am I even executing the work now?
Accordingly, it is submitted that on the disqualification of the petitioner on the same set of documents was a high-ended decision of the respondents, the official respondents. Next paragraph. The court is inclined to direct the Rural Works Department to produce a scanned copy of the documents which was uploaded in respect of the uploaded by the petitioner in respect of uploaded oblique submitted in respect of the tender, page 320, on the next date of listing, next body. As the non-counsel for the petitioner submitted that the execution of the work has started in the month of March 2023, list this matter on 22/4/2025.
The item 25, a similar, same ground, no difference.
Some other day. Other matters would be rolled over.
Yes.
I have to sit in the another division bench. And video conferencing.
Name of the petitioner was recorded in the year 2005 along with her husband. She produced a link certificate, my lord, that was land holding certificate issued by the competent authority, wherein, my lord, her name was shown to be as the daughter of Haran Sheikh.
Yes.
My lord, that is the link certificate. That certificate was not, my lord, questioned by the state at the time of, my lord, cross-examination of her of the petitioner, my lord. So, my lord, that is admitted by the state. If that is admitted, then, my lord, there will be no more, my lord, certificate is required for, my lord, establishing her link with her parents.
Okay, that landholding certificate is Exhibit C.
Yes, my lord. Exhibit C, I have annexed it, my lord. Page 23, my lord.
Yes.
22, 23, my lord.
The
Transfer
other
copies,
exhibits
please.
are voter list of 66, which is Exhibit A.
My lord.
The next is voter list of 1970, which is Exhibit B.
My lord.
The Exhibit D is the revenue payment certificate, receipt.
Yes, my lord.
And Exhibit E is the Jama Bandi.
Yes, my lord.
Which page is that? Exhibit E?
Not annexed in this petition, my lord. E is not annexed, my lord.
It's not annexed. The landholding certificate, you had said that it's the name of your father.
Yes, my lord.
But the
Haran
father's
Sheikh.
name appears to be changed.
Yes. In some documents, my lord, his name is recorded as Haran Sarkar. In some documents, my lord, his name is recorded as Haran Sheikh. Only the discrepancy of the title.
No, but in the landholding certificate, the father's name is
Yes.
Anwar Hussain. In the land certificate,
Sona Khatun, daughter of Haran Sheikh, my lord. Srimati Sona Khatun Pita Haran Sheikh or Nijor Namot Papa Zomi Hall. In the vernacular and the translated copy, page 22, my lord. The land is owned by Sona Khatun, daughter of Haran Sheikh.
Haram Sheikh. Okay, yes, yes. Yes, and you have cited the case of Muhammad Anwar Hussain versus Union of India, 2014 legal. Mr. Saikia?
My lord. Yes, my lord. Anwar
You
Hussain.
have cited the case of
my
Guwahati
lord.
High Court
My lord.
of Muhammad Anwar Hussain versus Union of India.
My lord, my lord. Paragraph 10, my lord. In paragraph 10, my lord, regarding the discrepancies in title and name, my lord, that has been, this court has observed. In my lord, last part of paragraph 10, my lord, insofar as discrepancy in name of petitioner's father is concerned, it is a common phenomenon in rural areas, more particularly among people of Muslim community, to have more than one name or there being variation in the name, such as in the name of petitioner's father. The discrepancy in the name as noticed Samed Ali, Abdul Samed, and Samed is not so great as to draw adverse inference regarding the citizenship of the petitioner. On the ground of there being such discrepancy in the name of petitioner's father, petitioner could not have been declared as a foreigner. Here also, Malat Sheikh in some documents, Sheikh in some documents, Sarkar. Haran is there. Haran in both the documents, Haran is there. Link to particle. Link to particles. Link to particles.
You're getting the voice now?
Yes, getting the voice now.
Anwar Hussain? Yes.
First got paragraph 10, my
Okay,
lord.
we missed out voice for some time. Yes, yes.
My lord. In last part of paragraph 10, my lord, I have read. Insofar, got it, my lord?
Yes.
Insofar discrepancy in the name of petitioner's father is concerned, it is a common phenomenon in rural areas, more particularly among people of Muslim community, to have more than one name or there being variation in the name, such as in the name of petitioner's father. The discrepancy in the name as noticed, Samed Ali, Abdul Samed, and Samed is not so great as to draw adverse inference regarding the citizenship of the petitioner. On the ground of there being such discrepancy in the name of petitioner's father, petitioner could not have been declared as a foreigner.
Yes.
Just
And insofar as the state is concerned, they have cited Rupali Bibi, Zelekha Khatun, and Sabir Ahmed. Mr. Sharma?
Lordship.
Your side, from Mr. J. Pang had argued, he had cited Rupali Bibi,
Lordship.
Zelekha Khatun, and Sabir Ahmed.
Lordship. But Lordship, in earlier on hearing time, Lordship, Mr. Pang was there, Lordship. So
Yes.
yes, Lordship. Another aspect is that, Lordship, regarding land holding certificate, Lordship, a tribunal clearly stated in para 28, Lordship. Exhibit C is the land holding certificate issued by the circle officer, where it is certified that there is a 3 plots of land, DAG number 688-220 and 221, recorded in the name of Sona Khatun, daughter of Haran Sheikh. The opposite party claimed that the above mentioned land is recorded in her name, but there is no proof that Sona Khatun, daughter of Haran Sheikh, and Sona Bhanu, daughter of Haran Sarkar, is the same person. Moreover, the opposite party, in her statement, has stated that she is now 41 years, and if she is 41 years, then as to why her name is not enrolled in any electoral roll prior to 2005. Lordship. And the opposite party also submitted one link certificate issued by the GP secretary, which is not proved through the person who issued the same. The opposite party also failed to prove that Haran Sarkar and Haran Sheikh is the same person, and the opposite party also failed to prove that Haran Sarkar and Gokuljan Nesa were her parents. The opposite party miserably failed to establish her link with her parents, which leads to reasonable doubt, Lordship. And Lordship, another aspect is there, most probably, Lordship, there is no statement regarding her landed property, Lordship, neither in WS nor in her evidence, Lordship.
So for that, we already have, I think.
And when person, father of the proceedee died, Lordship, that was also not mentioned, Lordship, in her. I think, Lordship, for better clearance, Lordship may fix another date for hearing, Lordship. Yes,
okay.
Short time will Regret, Lordship. Otherwise, there is no link, Lordship. And there is a lack of continuity also, Lordship.
Okay. Brother Kadak. Yes. Brother Kadak, you're hearing us? Brother Kadak, you're hearing me?
Yes, yes. Yes, sir.
Brother Kadak?
Yes, sir, I can hear you.
No, it's hanging.
Sir, I can hear you.
Brother Kadak, you're getting the voice?
Yes, yes, I can hear you, sir. I can hear you, sir.
Brother Kadak, you're getting the voice?
Yes, yes.
Mr. Saikia?
My lord,
You're getting the voice?
Lordship is audible, Lordship. Lordship is audible, Lordship.
Mrs.
We are getting your Lordship's voice.
You're getting the voice now?
Yes,
Yes.
yes, we're getting.
Yes. Oh,
We can
there's some
hear you, sir.
disturbance. Today there's some disturbance. Brother,
Yes.
then we close the matter and we'll pass the orders today.
Yes,
I'll consult with you and then we'll exchange the notes.
yes, yes.
Okay.
Okay.
Mr. Saikia and Mr. Sharma will try to do it in course of the day today. If we cannot upload, then it will be uploaded tomorrow.
My lord.
Yes. Yes, sir.
Oblige.
Sorry, could not.